That's right. Let's effing go.
I was just singing it in my head.
So, sorry y'all don't get AJ today. She'll be back tomorrow. She had some stuff to do today. But we're going to hop right into this. So, there's 2 videos I'm actually going to skip. Because one is the exhibits, and the exhibits that they show are ones we've already seen, and then they go through like a bunch of other exhibits, but they don't show them, so it's really pointless. And then we're gonna skip another guy because he does 44 minutes of testimony outside the presence of the jury, and then does 55 minutes in the next video with the presence of the jury, and he basically just reiterates everything he said. So, yeah, I'm not going to get into all that. But say hi to people. Hello, baby.
Oh, hello.
Frank said, dang, why am I always premature? Being a man sucks. Hello, Flash fan. Hello, Dark Boots / Lavi. And yes, I am. I had a really, really long day yesterday. Really demanding day yesterday. And it just ended up giving me a migraine. So it just got the best of me. Hello, Brandon. Let's go.
Hey,
can we
let's
see him
go.
waving through the windshield? We cannot. Unfortunately, we cannot. Hello, Michael. So again, sorry my mom's not here today. She's actually having dinner with my brother and my dad. So she'll be back tomorrow. But so what we're gonna do first is actually Brandon Biggs' testimony. It's only like 9 minutes long, but that is Greg Biggs, who went through the windshield. It's his son. So we'll hop into it, and then we'll get to the doctor or medical examiner or whoever. We'll get to somebody. All right, let's go.
Let's effing go. Sorry, it's stuck in my head now. You gotta share the screen, Carmen.
You may continue.
Thank you. Tell the jury your name, Brandon.
Brandon Biggs,
How old are you?
20 years old.
And are you in school?
Yes,
Where are you attending school?
in Waxahachie at Southwestern Assemblies of God University.
And what kind of degree are you seeking?
Church Ministries degree.
Where do you live right now?
I'm home for the summer in Albany, Texas.
Okay. And who do you stay with there?
My grandparents.
Do you know Gregory Biggs?
I do.
And how do you know Greg Biggs?
He's my father.
Growing up, did you live continually with your father?
No.
Okay. And what happened in your father's marriage with your mother that meant you weren't living together the whole time?
They divorced
And how
before I
old?
was too young to remember.
I'm sorry. I was going to ask you how old you were when they divorced, and you said what?
I was very young.
And who do you live primarily with when you were younger?
My mother.
And when you were younger, did your father remain a presence in your life?
He did.
How often did you see him?
His custody rights stated for bi-weekly visits over the weekend.
Okay. And did you see him on those instances?
I did.
Okay. And did he go to school functions?
A few athletic events, yes.
And at some point, did you actually go live with your dad?
I did.
And when did you go live with Greg?
I believe it was in 96 in my 9th grade year.
And how long did you live with him?
Approximately a year.
And what kind of work did your father do? What occupation did he have?
He was self-employed as a bricklayer.
And What kind of, so did he had his own business?
That's right.
What was his business called?
Biggs Masonry.
And did you ever go out on jobs with him?
I did.
What kind of work would he do in that field?
Mostly small jobs like retaining walls, planters, or mailboxes.
Okay. And was that pretty consistently the business he was in most of his life?
Yes.
And did your father have any kind of illness during his lifetime?
He did.
What type of illness did he have?
I believe he was diagnosed with bipolar disorder and mild schizophrenia.
And did he have medication for that?
He did.
And when he took his medication, did it control his symptoms as best you could tell?
Yes.
Did it prevent him from having a functional life and holding down a job?
Did his medication or did his illness?
Did either one of them, when he was on his medication, prevent him from doing that?
I'm not aware of the side effects of the medicine, but yes, sometimes his illness would.
Okay. And what kind of person was your father?
I would say he was very hardworking. He was very friendly. Although he didn't have many friends, he was very friendly. And he was very, very loving, I would say.
For most of your knowledge of your father's life, did he have a home and a vehicle?
He did.
And at some point, did he lose both of those?
He did, yes.
Can you tell me what the circumstances of him losing his home and his vehicle were?
Yes, he had moved off to Old Mansfield Highway in Fort Worth. He had found a girlfriend. She had fallen into some, well, if I may back up, he had begun living with her. He had then, she had fallen into some hard times. She had wrecked her car, and he had asked me one day if he should help her financially. I told him yes, I thought he should. And when he helped her financially, loaning her money, he was unable to make his truck payment, and that's how it was taken from him.
So without his truck, how was he able to continue working in his business?
He was not.
And ultimately, did he lose his home?
He did.
And once he lost his home, where did he live?
Well, shortly after that, he went down to the shelter on Lancaster.
And how long, prior to his death in October 2001, how long before that did these events occurred that left him without a home and a truck and a business?
1.5 to 2 years, I'd say.
Were you still able to keep in contact with your dad after he lost his home?
I was.
Did you still talk to him?
I did.
Did you still visit with him during that
Yes.
time period?
Yes.
What kind of stuff would you and your dad do together?
Well, like I said, he was on Lancaster, and he would do his best to keep in touch with me. It wasn't easy, but he would try to give me a number where I could call him. And so I would go visit him, and we would go to the mall or go to the movies.
And even after he lost his truck, do you know if he was able to get other employment while he was without a home?
Yes, he was.
And what type of work was he able to do?
He began driving a bus, I believe, for the school district of Fort Worth.
And he did that after he lost his home.
That's right.
Was there some time period, month in the year 2001 when you lost touch with him?
Yes.
About when was it that you stopped hearing from your dad?
In July, in the summer of 2001.
Okay. And after July of 2001, did you ever have occasion to have a conversation with him on the phone or see him?
No.
And at some point, did you get news that your father was dead?
I did.
And was that in October of 2001?
Yes.
Where were you living at the time?
With my grandparents in Albany, Texas.
Okay. And were you in college yet, or were you still in high school?
I was approaching my senior year.
And when you learned about his death, were you able to find out at that time many details about how he died?
No,
Did your father have a funeral?
he did.
Did you attend it?
I directed it. I planned it. I handled it.
May I approach, Your Honor?
You may.
I'm going to show you what's been marked as State's Exhibit 189. Do you recognize this picture?
I do.
And is this a picture of your father as he looked at the end of his life?
Yes, it is.
It's actually his driver's license picture, isn't it?
I believe that's right.
Your Honor, we would offer State's Exhibit number 189 as evidence.
State's Exhibit 189 will be admitted.
And Your Honor, I believe there's a stipulation between the state and the defense that this is one and the same person as is shown in State's Exhibit number 92.
That's correct. We'll stipulate. All right.
Thank you. May I publish State's Exhibit number 189 to the jury?
You may.
I'll pass the witness, Your Honor.
No questions.
You can step down.
And that's literally all he said. So
Legit, YouTube won't even let me say anything.
that wasn't.
I've been talking the whole time, and it wouldn't let me say. And it was just regular things. Like it didn't have any swears or nothing in it.
It did that to me yesterday, I think, or that or the day before. But I don't know why she's in tears. You weren't in tears when he was in your windshield, which I was told by my mother to. So there are several reports out there, which is where we got our information from, that state that he was in the windshield for 2 to 3 days, or before he passed away. The testimony that was given yesterday states that's not true. It was he was hit this day, he was found the next day. So I was told to clarify that. She said to tell you that we're not crazy. There is there's several things out there that state that he was in there for several days. Apparently he was not. So the next guy that we're going to get to, I'm going to skip his one that is without the presence of the jury, because he just reiterates himself. And I don't feel like listening to that for 44 minutes and then listening to it again for 55. So, all right, let's get into this one. Add to stage. I always forget to do that. So this is, no, I'll tell you who he is.
Good afternoon, ladies and gentlemen. Counsel, the defense, you may call your next witness.
Dr. Mallard, would you state your name for the jury?
My name is Dr. Vincent Mallard.
What do you do for a living?
I'm a physician employed as the chief medical examiner for Bexar County, which is essentially San Antonio and about 20 other municipalities.
You hold any other present positions?
What?
You hold any other present positions?
I have a position as a professor in the Department of Pathology at the University of Texas Health Science Center in San Antonio, the medical school. And I'm the editor-in-chief of the American Journal of Forensic Medicine and Pathology, which is the only forensic pathology journal published in the United States.
What are your qualifications to hold those positions?
I graduated medical school in 1965 from State University of New York Downstate Medical Center. Following that, I spent 4 years additional training in anatomical and clinical pathology at Duke Hospital in Durham, North Carolina, and the Kings County Downstate Medical Center in New York City. Then spent a 5th-year training in the field of forensic pathology at the Office of the Chief Medical Examiner for the state of Maryland. And then took my specialty board exams and was certified as a specialist in the 3 fields of anatomical pathology, clinical pathology, and forensic pathology. Went into the Army for 2 years, And I was assigned to the Armed Forces Institute the Armed Forces Institute of Pathology in Washington, D.C., where I was chief of the medical legal section for 1 year, chief of the wound ballistics section for the second year. Got out of the military, moved to Texas, was a medical examiner in Dallas from 1972 to 1981. Moved to San Antonio in 1981 and became the chief medical examiner. And I've been there for the past, 22 years.
Do you have any memberships in any professional groups?
The National Association of Medical Examiners and the American Academy of Forensic Sciences.
Okay. Have you received any awards in your field?
I received the Master's Teachers Award from my medical school a couple of years ago. And then I received 2 awards from the National Association of Medical Examiners. One was the George E. Gantner Memorial Award. The other was the Outstanding Service Award. And then I received the Milton Halpern Award from the American Academy of Forensic Sciences this past February.
Have you written any books in the field of pathology?
I've written 3 books, a handbook of forensic pathology. I'm the senior author. The other author is Dr. Dana, who works in my office. A textbook called Gunshot Wounds, which I'm the sole author. It's in the 2nd edition. And I've written a book called Forensic Pathology, which is the general field of forensic pathology. And I wrote that with my father, who was chief medical examiner in New York City.
Have you written any articles published in peer-reviewed journals?
I've written 78 articles, 11 scientific letters, and 10 book chapters.
Okay. And did I hear you say correctly that you're also the editor-in-chief of the American Journal of Forensic Medicine and Pathology at this time?
Yes, sir.
How long have you held that position?
Since 1992.
Would it be fair to say that essentially you do in Bexar County what Dr. Pirwani does here in Tarrant County?
Yes, that's true.
All right. Out of a given 40-hour work week, how much of your time do you spend working on cases in your capacity as the Bexar County medical examiner?
As a medical examiner, at least 40 hours a week, usually runs longer.
Okay. Do you also do some independent consulting on the side?
That's what I'm doing here. I'm an independent private consultant, right?
Of the total amount of time you spend working, how much time do you spend working on cases for defense lawyers?
Maybe a Saturday. But, well, not defense lawyers. I do very few, I do a lot of civil cases and then some criminal cases. And the criminal cases are half defense, half prosecution. And then maybe I do a Saturday on them.
And that's of your side cases?
That's my side cases, right?
Of the times that you come to court to testify, how many times do you testify for the prosecution as opposed to the defendant in a criminal case?
In all criminal cases, probably 95% prosecution because I'm the medical examiner. I'm called by the DA to testify.
Okay. What did you review in preparation for your testimony here today?
Essentially, I reviewed the autopsy report on Mr. Biggs, photographs of the body, the scene, and the vehicle, and also a police summary written concerning the incident.
Okay. Did you talk to any of the prosecutors before testifying here today?
No, sir.
Did you bring materials that you were requested to bring to court?
Yes, I brought my whole file.
And you have your whole file here?
Yes, sir.
Generally speaking, what did you think of Dr. Pirwani's autopsy?
Oh, it was excellent autopsy. I don't want to embarrass him, but it was a real good autopsy. Yeah.
Okay. Do you have any differences in opinion with him about his interpretation of the autopsy?
Now, we disagree in interpretation, but his autopsy is a good autopsy.
Let's start with this. Do you agree with his finding on the cause of death?
Yes. The cause of death is essentially that he bled to death by virtue of the almost complete amputation of the left leg. And he also had fractures in which he was also bleeding internally from.
Okay.
But it's mostly the leg.
Okay. And would you agree that if Mr. Biggs had received reasonable medical attention in a reasonable amount of time, he would have survived his wounds?
Yes.
Now I want to ask you about a few other things. Do you have an opinion as to whether or not Mr. Biggs was conscious when he entered that car?
No. Well, yes, I have an opinion, and my opinion is he was not conscious.
Why not?
Essentially, he was struck, lifted up, hit the hood, which is all dented, and then slid into the windshield with his head. And he knocked out the windshield. Well, you're not supposed to knock out windshields when you hit them. And essentially, his head, followed by his weight, he hit it with such force that he literally knocked the windshield out, and he went into the compartment of the vehicle. And what I'm saying is if you knock a windshield out with your head, you're going to be unconscious.
And now a couple more questions about this. Do you have an opinion as to whether or not his head hit the frame up above the windshield, the metal frame?
No, it would have to have been probably his arm. If his head had hit the metal frame, you would have seen the scalp. There would have been a shear off of the scalp, a slicing type injury, a really big one, and there also would have been a skull fracture because it's steel, and your head is not as strong as steel. You run into a piece of steel with that velocity, you're going to dent it. On top of which, if he had done that, he would have just bounced right off the vehicle. He would not have gone in.
Now, is there something about the way windshields are designed that would explain why he was able to go through the windshield without fracturing his skull?
Yes.
What is that?
The windshield of the car consists of a piece of plastic, thick plastic, transparent plastic, with a sandwich, one on each side of a thin layer of glass. So when you look through the windshield, you think it's glass, but it's really thin layer of glass, clear plastic, thin layer of glass. And it was designed that way so people don't go through the windshield, actually. What happens is when your head hits the windshield, the glass breaks, which is no big deal because it's little pieces. And then your head hits the plastic, and the plastic is supposed to give to a certain degree. And so what that does is it slows down your head. That's why you have padding on a car. And it slows down your head, because if your head hits something and stops suddenly, then you get fractures. Then you get hemorrhage into the brain. So what you want to do is slow the head down, and that's what the windshield's for.
Okay. Is there any medical way to tell if he had a concussion?
Concussion? No. You can't tell. Concussion is a physiological thing, When you get hit and you're knocked out, you have a concussion. But if you take that person's brain and then examine it right then and there, you're not going to see anything.
So from your analysis, he either could or could not have had a concussion from the medical analysis, correct?
From the autopsy, you can't say whether he had a concussion. But what I'm saying is he had a concussion because his head knocked out the windshield. Just when he hit with such force, he had to have been concussed. He had to have been knocked out. I can't see any other way.
Do you have an opinion as to the chances that he regained consciousness once inside the car?
You can theoretically regain consciousness, but it takes a long time. It's not like TV where you get hit over the head and you wake up in a minute or two and you're fully conscious. What happens is it takes a while. And, how long would he have been unconscious from this blow? I can't say 100%. It's not minutes. It's much longer than that. Half an hour, maybe an hour. Maybe longer. I can't say. There's no way to say. If I told you that, it wouldn't be the truth. But the thing is it was a bad blow to the head. He would have been unconscious. If he then did regain consciousness, it would be a slow evolving process of, being confused for a while and then gradually coming out of it.
Was there anything else going on with him physically that would have impeded him being able to regain consciousness?
Well, yes, he's bleeding. He's losing blood. And as you lose blood, you gradually grow weaker. And you eventually, if you lose enough blood, 35 to 45% of your blood, you go into shock. And then once you go into shock, you're going to be unconscious. It gets a thing. What happens is you're say, let's just forget about the windshield. If you just stop bleeding, you start to feel weak.
Honestly, though, that makes me feel a little bit better that he was probably unconscious for a while.
Well,
Instead of just sitting there and just agonizing, even though he'll get, like, we know that he gets to that point, but at least it wasn't just the whole time.
yeah. Well, what I said the other day was, his adrenaline was probably rushing so high that he couldn't feel everything,
Right. Yeah, which was, I mean,
Freaking
probably
crazy, man.
for the best. Ha,
Yeah.
you got me just in time. I have the tab just right there. And I just about cracked it. You could be streaming. Yeah, Indiana clown pie later if you want to talk. So let's go. Anyway, buddy. Thank you for the $10 super chat. I appreciate it. I know my mom appreciates it. And as always, all the super chat, super stickers, membership, gifted memberships go towards a new computer for her because she needs one. She needs one bad. All right, we'll keep going.
Weak and cold, your heart beats fast, your respiration is very fast, and then you start to get, a little foggy, confused, and then you gradually go unconscious. And then it continues long enough, you die.
Now, do you have an opinion as to whether or not Mr. Biggs died of asphyxiation?
He didn't die principally of asphyxiation. Now, the fact is that he's wedged in to the front of the car, between the front seat and the dashboard. And and he may have been fully in, or his legs may have been partly sticking out. But the problem basically is you're lying in that position, is you're going to get compression of your abdomen, which is going to interfere with your respiration. When you breathe with your chest and you breathe with your abdomen. And if someone sits on your abdomen, you can still breathe, but it's more difficult. And he's put into the front, in a wedge type position, and it's going to interfere with his respiration. He's not going to die of asphyxia from that. But the problem with losing blood is a way of asphyxia. You lose blood and your organs die because the blood can't carry oxygen. But if at the same time you can't get that much air in, you've got bigger problems. So it definitely didn't do him any good.
Is the fact that the autopsy didn't reveal the discoloration of the face or the
Petechiae, small hemorrhages.
that Dr. Pirwani talked about, does that mean that there was no interference with his respiration from the position of his body?
No.
Why not?
It doesn't, because what we're talking about is a different thing. When you get the congested face and the petechiae, you'll get severe compression of the chest, and the blood is literally forced from the chest up to the head. That's the people going, changing oil under a car, and it slips off the block and lands on their chest. This is different. This is kind of like someone, sitting on your chest or something, and, you don't get petechiae, you have a little difficulty breathing. But that's what it is. It's not, and especially here where the person's not dying of it.
Have you seen any cases like this or a case recently where someone died of asphyxiation like this?
Yeah, I had a heavy individual who was in a vehicle, and it turned over, and it was a small vehicle and a big person, and they got wedged upside down with their head kind of bent down, and all the way down, they couldn't breathe. They died.
But just so we're clear, you're not saying he died from asphyxiation?
No, he died from loss of blood. The asphyxiation just made it worse. Or the asphyxia, it's not asphyxiation. The lack of oxygen would have made it worse.
Would it be fair to say that it hastened his death?
In all probability, yes.
Okay. Have you formed an opinion as to how long Mr. Biggs could have survived without medical attention given his injuries?
I I would say that he survived somewhere between 1 and 2 hours. I don't think longer than 2 hours. I've seen people die in less than an hour, but usually they had some.
So that goes along with what I was correcting my mom and I on earlier. There's a lot of reports, like people that are just now joining. There's a lot of reports out there that he was alive 2 to 3 days. Now watching these testimonies and going through them, I mean, thank God on his part that he wasn't there for 2 to 3 days. He was most likely just alive for a couple hours.
My eye is twitching.
Is it because this guy's eyes?
Like, I can't even look at his face because of his eyebrows. It's just like eyebrows gone wild and then a little twitch on his cheek.
That's so mean.
I mean, he might have an issue with like his muscles in his face, but I don't know, but I can't look at it. It's like making me dizzy or something.
Sharon says, this is so dumb. I don't understand why they have the jury in the first time. Exactly. That's why I just went ahead and skipped the first video where it wasn't in the presence of the jury. And this video is in the presence of the jury because I wasn't going to watch it twice. That would be a waste of everybody's time.
No, Zach, actually, it's not slowing down. My husband caught a bunch of smallmouth the other night.
Yeah, I heard that Mr. Gabby catches way more fish than you do.
You know, I mean, gotta put in the time.
Exactly.
Gotta put in the time.
Something else going on, like heart disease. So I would say that in all probability it's between 1 and 2 hours.
Okay, and does that calculation take into account any asphyxia he may have had?
No, actually, it's just talking about bleeding because I can't quantitate the asphyxia.
Okay. The near traumatic amputation of the left leg, did that sever any arteries or veins?
It would have gotten, obviously it got the veins, the anterior tibial, posterior tibial, peroneal, it's P-R-O-N-E-A-L. And those are the arteries. And then you've got the corresponding veins. So the arteries pumping blood out, and the veins, it's just some of it's leaking out.
Okay. Do you have an opinion as to whether or not Mr. Biggs was in all probability communicating verbally after his injuries?
I don't think so. And the reason I said that, and the basis of my opinion, is the initial concussion, followed by the fact that after that he's gradually going into shock.
Okay. Now, would moaning and groaning be inconsistent with your opinion?
No, it's not inconsistent with opinion.
Okay. Would some bodily movement be inconsistent with your opinion?
No. I mean, the person isn't dead. The person is unconscious, and you can still move if you're unconscious, you know.
Would he have been making, is it possible he could have been making involuntary movements to get himself in a better position to get air?
Sure. I mean, you know, it's like when you're asleep. I mean, you're not conscious, but you're still moving.
Ultimately, why do you think Greg Biggs died?
The reason he died, I think that he died as a result of loss of blood. And the loss of blood occurred because he didn't get medical attention.
Now, I want to turn you to kind of another area. Have you reviewed the work records of Chante Mallard that were put into evidence earlier?
Yes.
And let me, for the record, look at those and get the exhibit numbers. Doctor, I'm going to hand you what had previously been marked and admitted as States Exhibits 186, 187, 188. Are those the records you reviewed?
Yes, sir.
Now, did you read every single word in those?
No, I leafed through them. A lot of them are just tests. But I thought the thing that was most interesting was the description of what the job was.
Okay, what is, from looking at these records, did you find out that Ms. Mallard was a CNA?
Right.
What is a CNA?
A certified nursing assistant.
And based on those records and the job descriptions contained therein, what is it that Ms. Mallard was employed to do?
Essentially, it is not true nursing. It's kind of care. That is, what they do is they change the bed linens. They, take away the urinals. They dress the patient, wash them, move them in bed. They'll feed them. And so it's more of a custodial care than true medical. They may take some vital signs, heart rate, respiratory rate, but it's mostly providing care, like a mother caring for a child, rather than nursing per se.
Now, from your review of the records, did you find out that she'd had CPR training?
Yes.
Can you tell me what basic CPR training is?
Basic CPR training essentially is, chest compression, mouth-to-mouth resuscitation, that sort of thing.
Okay, did you notice if she'd had basic first aid?
I think there was some of that, yes.
Okay. What is basic first aid?
Again, it would be, it's not very medical. It's mostly, evaluating a person. One of the jobs that you would have would be, if the patient looked like there was something wrong, and then they would go summon a nurse, because they're not qualified to do any true nursing.
Okay, do they know how to take vital signs?
Yes, they can take vital signs.
Okay. Do you know if you would expect a CNA to be able to call for help if something happened?
That's what they're supposed to do, right? Cool.
Assuming they're in their right mind.
Right.
Pass with it, Sean.
Thank you, Your Honor. Dr. DeMarco, if I could one more time ask you to show me what records the defense provided to you in preparation for your testimony.
Yes, sir.
Thank you.
One moment. Hello. Sorry, it's not my mom today. It's me. I believe. Gabby, do you remember who gifted memberships yesterday?
Carmen, I barely remember this morning.
I don't remember who gifted it yesterday. My apologies.
Oh, it was someone from Baker's when they came in.
I knew it was somebody from Baker's.
It was the first person who jumped into chat from Baker's. Can't remember their name. What? Say it again.
Was it Haven?
I don't think so. No. Yes, let's go. I'm a mod. No, it wasn't Danny. It wasn't Sue.
I don't remember. I'd have to go.
Because they did it. I remember it was a name where.
That's what I thought it was.
Was it Haven then?
Yeah.
Yes, Hellfish.
Yeah.
Yeah, it was Hellfish. Yeah.
Good job, Zach. You were good for something.
I knew once I saw. Well, you said Haven. I wouldn't have even remembered that, but I remembered Hellfish. Yeah, it was Hellfish.
Yeah. But yes, that would. So I don't ever call anybody by their full name. Rose, yes, that was Hellfish Haven that did that. We are very, very happy to have you. We're just finishing up some testimony, and then after this, we're going to get into closings. We still won't be done because we got penalties and stuff like that, but
Let's
it rolling.
beep and go.
Let's effing go.
Let's do this.
Coach Schroeder, you may.
Ooh, piece of candy.
So I'm clear on this. What you provided me are photographs, crime scene photographs taken of the vehicle, both at Chante Mallard's house, photographs of the scene where Mr. Biggs' body was found.
That's correct, sir.
Right. We have photographs of the body, some of which were taken at the medical examiner's office, again, some of which appear to have been taken there at the scene.
Yeah, probably the investigators.
Right. And again, appears to be more crime scene photographs.
Right, I think they're duplicates.
Okay. And as far as recitations regarding the purported facts of the case, we have the full autopsy report of Dr. Perwani
Yes, sir.
that you've relied upon and read, and you agree on the cause of death and manner of death.
Yes, I do.
Manner of death would be what then?
Could be homicide.
Okay.
Whenever, in my county, whenever.
And doctor, I don't mean to
Okay.
interrupt you, but.
That's fine. I agree.
Okay.
I'm just going to agree with you even more, but
Only if it's the truth, okay?
it's the truth.
You also have a 1, 2, 3, 4, 6, 7. You have an 8-page, it looks like a summary of the police report.
Yes.
Okay. And of course, the rest of this is just correspondence.
Yes.
Okay. So what I'm not seeing in there anywhere is a copy of the signed confession that Chante Mallard gave to the police.
That's correct.
Okay. So in forming the opinions you testified to today, did you rely at all on what Chante Mallard said happened in this case?
No, what I relied on was essentially the autopsy report, the photographs, the physical findings, and a general account of what allegedly happened.
Okay. But that did not include her statement.
Right.
And it didn't. I don't see in there the grand jury transcripts for the testimony of the witnesses who testified about the facts of this case. Sworn testimony of T. Fry. I don't see a copy of the statement given by Cleet Jackson.
Right.
I don't see a copy of the videotape statements given to an investigator by T. Fry, Cleet Jackson, or Tyrone Cleveland.
That's right. I told you what I considered.
And I heard you, and I just want to make sure. So witnesses that were there at the scene, their explanation of what happened wasn't what you relied upon. You relied upon the objective physical evidence in this case and a summary of the police report.
Yes.
Okay. And in your work as a medical examiner in your own county, when you come up with findings as to cause and manner of death, would you typically take into account confessions given by defendants, eyewitness statements of what happened? Would you consider those along with your medical findings in forming your opinions?
It depends on the case.
But you have done that before.
Yes, right. And, it depends. On some cases, the investigation by my own investigators plus the autopsy is sufficient. It depends.
Okay. But would you turn that information away?
Oh, no.
I mean, as an investigator, especially in your own county, your job is basically to seek the truth in terms of the cause of death,
Yes.
correct?
Cause and manner of death.
And sometimes there are gaps in what you can tell from looking at the physical evidence. Is that correct?
Right. That's why you take into account the description and the circumstances leading up to and surrounding the death.
Okay. So for instance, in terms of how you can form your opinions, you can look at records, or if you're actually doing the autopsy, you can make determinations in a range of when a person died, correct?
Depends upon the case. I'm right. Yes, the answer is yes, depending on the case.
And I'm not meaning to apply any exactitude to that. I'm just saying a range.
Right.
But more specifically, if there are witnesses who can place the victim alive at a certain point, then that information could be helpful in determining the question of when they died.
It could be helpful, but as you're quite aware, that witnesses aren't always reliable. And so it's always best to try to base your opinions on objective findings.
That's true, but not to the point of ignoring subjective testimony and renditions of people that were actually there.
Right, but the problem is that the subjective testimony disagrees with the objective, that you should stick with the objective. It's not that people are necessarily lying. Also, it's that people see things differently or misinterpret. And so it's always best to try to deal with hard physical evidence rather than get into subjective observations.
Okay, well, let's talk about the hard physical evidence of some of your findings. Tell me what the hard physical evidence is of the concussion that you say Mr. Biggs sustained, unless, of course, you mean the hard evidence was the hard windshield.
The hard evidence is the fact that he went through the windshield, right?
Okay.
That's physical evidence.
And how long have you been preparing to come testify?
Hold on a second. Rule number 1, not being a blank. Unfortunately, it's actually leaving. You are saying you are leaving. I had a joke in mind, but this is my mom's channel and I can't say it. Do I have to leave? That's as far as I'm going to go. I had a better joke in mind, but I can't say that on my mom's channel. She'd get a little upset with me. But that's a good one.
I wasn't preparing to come testify. I was contacted about a year or so ago, and I wasn't getting contacted until recently, and they just wanted me to come down.
Let me ask it a different way. When did you get the information you just showed me, the pictures, summary, and all that?
About 2002.
Okay.
I think May.
And informing your opinion about the force it would take for a head hitting a windshield to knock out the windshield. Mm-hmm. Did you ever take the time to contact the manufacturer of that vehicle and find out from its own information what that force would have to be?
The force to drive a head through a...
Yes, sir.
I've never heard of anyone. I mean, I haven't contacted because I've never heard of anyone. You have to propel bodies through windshields.
Well, Dr. DeMaio, you've never seen crash dummies?
Yes, but there's a little difference in crash dummies and putting people. Essentially, the only way
Dr. DeMaio, my question was, have you ever seen crash dummies?
I've seen photographs of crash dummies.
You don't have any idea what information the manufacturers of those automobiles rely upon to determine the strength of those windshields and what force it takes to knock them out?
That's correct.
You didn't contact them.
That's right. All I can do is based on all the cases that I have where the people don't go through the windshields, they hit them and bounce off. And my studies actually, if you think about them, are better because they're using dummies. And my observations are based on real situations where people hit the windshield and bounce off.
All right, we got to test this theory. Oh, Papa Zach, I need you to drive to my house. You're not that far. I got a car over there. Let's go test this. Let's go test this theory. See how much force is needed. I'm sure Lesko would appreciate that one. So, but yeah, just drive to my house and I'll take the camera outside and we'll see what's up.
In your observations, what observations have you done about that particular make and model vehicle and the windshield on that car?
I haven't done particularly on that car. All I can say is that virtually never does a person go through a windshield. Never. Deer go, steers go, people don't.
Okay. And is it your testimony also that every time a person has a concussion, they must lose consciousness?
Actually, based on definition, yes.
Okay. And is it your opinion that loss of consciousness can never last for just minutes?
No. It depends upon the degree of unconsciousness.
Doc, I got to stop you. What does no mean? No, it could, or no, it couldn't last for minutes?
No. Mm-hmm. Okay. Yes, it can last for minutes.
That was my question.
It depends on the degree of concussion. Right.
Okay. And the degree of the concussion is going to be determined by the speed of the vehicle at the time it's hitting the individual.
Right.
And your study of the circumstances of this case, you never examined the vehicle, for instance.
That's correct, yes.
Okay. And when you say knocked out the windshield, is it your opinion that the glass that is missing from the windshield being knocked out was all caused by Mr. Biggs' head hitting it?
It had to be. Yes.
Okay. So if there's testimony before this jury that the defendant herself knocked out the glass of that windshield in an effort.
Objection, Your Honor. That is a misstatement of the record. The record shows that someone knocked out that glass with a hammer, and there was no evidence whatsoever about who touched that hammer, who used it, or anything else.
All right. Jury will recall the evidence.
Doctor, if there's testimony from a person that was with and spoke to the defendant that night, where she told them that she pulled over in a warehouse area and bashed the windshield out, sustaining cuts on her arm, would the fact that she helped knock out...
Objection, Your Honor. That is another misstatement of the record. There was no testimony that she bashed the windshield out.
All right.
Assuming facts, not in evidence.
All right. Jury will recall the evidence.
Did you hear my question?
Kind of.
Okay. Does the fact that if the defendant did, if recollections differ, and if the jury recalls that there was testimony that the defendant said that she did remove some of the glass of that windshield prior to getting the car back to the garage, is that going to have an effect on your opinion?
No, because if he didn't go through the windshield, he would not have been in the car. He would have rolled off and he would have been found at the seat. Usually what happens when a pedestrian gets hit, they hit the glass and they roll off. But obviously he didn't roll off. And if he didn't roll off, he had to have gone in. And if he went in, he had to have gone through the glass. There's just no other way.
So there doesn't matter the degree or how much of his body initially went through the glass for your opinion about the fact that he had a concussion.
Right, because right. And it has to at least.
Sorry, I'm gonna keep stopping. Ask my mom tomorrow because I don't remember. I think you're right. But I really don't remember. I can keep playing this and get the answer for you. But she's a better one to ask and she'll be back tomorrow. So I apologize for not having the answer to that.
Okay. The physical evidence at autopsy indicates that at least, in my opinion, 2/3 to 3/4 of the body went in.
Okay.
But if less than the body went in, the body would have fallen off. Obviously, it had to go in so that the mass was greater on the inside than the outside.
Or enough of the windshield was left that the windshield itself was holding part of his body in place. Is that possible?
That's possible, but still, it doesn't make that much difference because the head is going to punch in the windshield.
Okay. So you agree that the range of time that Mr. Biggs could have lived is 1 to 2 hours?
Right.
Okay. Can I ask you a hypothetical? If we have testimony, and this is State's Exhibit number 160, can you see that?
Yes.
Let me move over here. Okay, there's testimony that this defendant, Chante Mallard, leaves a friend named T's apartment at 2:51 a.m. Okay?
Yeah.
And that it takes 10 minutes to get from T's apartment to Chante's home.
Yes.
Okay? On the way from T's apartment to Chante's home, she strikes Mr. Biggs. Okay?
Right.
All right. And at 3:50 a.m., which is approximately how long from the time she leaves the apartment?
Okay.
About an hour?
An hour. Yeah.
Okay. Chante leaves her house after parking her car in the garage with Mr. Biggs in the car.
Right.
With me so far, my hypo?
Yes.
From what you told me, Mr. Biggs could very well have still been alive because we have less than an hour there.
That's right.
And it's possible, even with a concussion, that over the span of up to 2 hours, that he could have come in and out of consciousness.
Well, the longer you go from the time, then you start getting in the blood factor. Remember, you've got two things.
No, I understand, and I'm just asking. I understand what you're saying, but my question is: can you say to a medical certainty that he did not go in and out of consciousness during that time period?
I think it would be doubtful that he ever regained consciousness.
Okay. And I'm not talking.
But I can't say.
Okay, I'm sorry. Didn't mean to interrupt. I'm not saying that he carried on a lucid conversation asking her about family and friends. What I'm saying is the ability to make moaning and groaning noises.
Oh, yes, I already said I said that before.
Okay, so you believe during that time period that if someone said that they heard him moaning and groaning, that there's nothing inconsistent.
That's correct.
Okay.
But again,
Anybody that's in the medical field here, correct me if I'm wrong. Because they also, for one, I don't speak French. I just saw a kissy face at the end and thought that she said something nice. that Ash said something nice. I have no idea. She could have told me to go F myself. No idea. But people in the medical field, I've had people moan and groan who were not conscious. Like I had an individual, he was 19 years old, had attempted to self-delete by using his jumpsuit and a pipe. I'm sure you guys can fill in the rest. And he was like brain dead, but he was still making sounds, but he was not there. And so maybe he was, and I just completely read it wrong. But I mean, I've had people in there. I've had another guy who fell in the shower with several other inmates in there. And he was, I mean, I could sit there, do a sternum rub on him, pop an ammonia capsule, slap him in the face. Not that I did that one, but I could sit there and do anything. And he was still moaning and grunting, but he was definitely not like aware of anything. Yeah. No, talking about the patients. Patients are the one moaning and groaning to the doctors, especially with that colonoscopy you got coming up. On a serious note, anytime air passes through the vocal cords, sounds can be made. That can happen after death too. You're correct. I mean, I know that you are correct, but it made me think of something in a more personal scenario where I had somebody close to me pass away that I was there for, and they also did that. They had made some sounds after they had passed away. So okay, that makes more sense to me. Makes way more sense.
So you get towards the end of the 2 hours, the less likely it's going to be, right?
Okay, but certainly within that first
Yes,
hour.
right.
Okay. And you gave an opinion about what position he was in the vehicle.
Right.
Okay. And the information you relied upon to determine the position of his body in the vehicle was provided by the defense attorneys.
Right, and that was one scenario, and the other one was that his feet were sticking out, and that was based on the physical evidence.
Okay.
Right.
May I approach, Your Honor?
You may.
This is State's Exhibit 110. And you understand that this purports to be a representation of the same make and model vehicle that Chante Mallard was driving?
Yes.
Okay. So, and you would agree with me, this is the passenger side?
Yes.
Okay. Based upon your opinion about, now, he didn't asphyxiate, but his breathing was affected by his position.
Yes.
Is that fair?
Yes.
Okay. What position do you have him in while he's still alive that supports your belief that his breathing was restricted?
There were two descriptions given. One was that his head was on the floor, and that his rump was sticking up, but still in the car.
All right. And I want to make sure, I want to get position and everything like that in it. So let's start with the head. One description that you relied upon was his head is in the floor. Is his head face down or face up?
I don't know.
Okay. And is it going to matter on your opinion?
No, because I'm talking about restriction of respiration on the end.
Okay, let's take them one at a time then. If his head is face down, okay, where in that description would his legs be and his buttocks be?
The buttocks was up. He was kind of like in a frog-like position. That was my understanding.
Okay, so the buttocks is if someone were to be facing the buttock area, where would they have to be to see them? Do they have to be sitting, looking at it from this way?
Well, I mean, anytime you look, I mean, if the head's here,
right,
the buttocks is here, with the feet there.
Okay.
That's one position.
Okay, now under that position, under that scenario, it's not physically possible for the buttocks to be breaking the plane of where the windshield would be, is it?
That's correct.
Okay. What is the other scenario?
The other possibility is that that only part of his leg, say from the mid calf, that region down, is outside, and he's draped over the dashboard with the head down here.
Okay, so the parts important to breathing are going to be the diaphragm. Am I doing this right? Diaphragm and the chest.
And the chest.
And what part of the car are they resting on?
The diaphragm would be resting upon the curved dashboard.
Okay, and what effect would it have if he's using his left arm for support? Would that affect the pressure?
You would, okay, well, you have to push yourself up to get the pressure off.
Right.
Right.
You'd have to press on something.
Yeah, but you'd have to completely support yourself.
Well, you wouldn't have to completely support yourself. Any amount of support would relieve some of the pressure.
But you have to be conscious, of course, to do it.
Right, and you also have to be conscious to reach inside. Could you step down there for a minute?
Sure.
With the court's permission?
You may.
Also, this roll.
Judge, may we get one of the investigators to help us?
I don't want to make a major movement. Really, if you just move the screen, I think we can do this.
Your Honor, at this time, we're going to renew. May we approach?
Dr. DeMont. Okay. Understanding that we obviously don't have the whole car in here. Right. Okay, though, as you can tell, we certainly tried. And using this as frame of reference, this picture kind of shows it. You see this, what would you call this part right here? What is your word for that?
Door panel.
But the pocket part.
Oh, the pocket. I guess I'd call it a pocket.
All right, the door pocket. You see the door pocket on this side?
Yes.
If that door is in the position you would expect it to be in relation to the seat.
To this.
Right, and we have Mr. Biggs' body going through the windshield. Do either of the scenarios you talked about, would he be able to be gripping, sticking his hand in and gripping right inside that pocket?
Gripping?
Gripping?
No.
Not under neither of those scenarios?
No.
Okay, thank you, sir. I want to talk about certified nurses' assistants. And I think you may have mentioned some of this, but certified nurses' assistants, you would agree with me, there's a difference between the things they actually are called upon to do in their jobs and the things they're trained to do. Let me give you
Okay. Let me think about that question.
Let me try with an
Okay,
example.
go ahead.
They're trained to do CPR,
Yes.
right? They go to a CPR course.
Yes.
If a patient's in distress, do you expect the person to be administering CPR they're going to turn to the nurse assistant and say, you do it?
What they're supposed to do is call the nurse.
Okay. But that doesn't mean they're not trained to know what to do.
Right. But
And because sometimes the nurse isn't going to get there as quickly as the nurse needs to get there.
right.
And would you agree with me that in these assisted living environments, the certified nurses assistants have regular contact with the residents?
Yes.
Okay. And they need to be able to tell and recognize when a resident is in distress.
Yes.
And they need to be able to differentiate between mild distress and serious distress.
Yes.
You would also agree with me, would you not, that they have to be able to tell when one of the residents has died?
Yes.
Okay. Because that could pose a problem if they weren't able to recognize that in the course of their employment.
Yes.
Okay. And you did see in there that she knows how to take vital signs.
Yes.
And there's a number of tests that she takes, testing how she would deal with situations. Did you look at those?
Yes.
Did you grade those?
No.
Okay. Any reason to doubt that she answered those questions correctly?
No.
Okay. And did you notice in there that she's worked for more than one different hospital or assisted living environment?
Yes.
Okay. Did you count how many she worked for?
No, I didn't. I think that my impression was could it be five?
Five or six?
Yeah, it's like 3 on one and I think 2 on the back, and that was application. So
So a certified nurse's assistant is far less qualified than a nurse.
Oh, yeah.
But would you agree with me that they have more training on how to deal with situations than your average layperson?
When you're expressed it that way, yes.
Okay, because they are certified.
Yes.
And whatever the requirements of certification are for nurses' assistants, though they're probably far below for nurses themselves, there are some standards, some minimal standards that certified nurses' assistants need to be able to make.
Yeah. But I would think that if you even mention to a nurse anything comparable, she's going to probably slug you.
Okay. I wouldn't mean to, and I'll tell you right
Okay.
now, there's a very definite reason. I'm related to a nurse in this room, and I'm not going to say a nurse and a nurse's aide are equally qualified.
Okay.
But nurses rely on nurses' aides to know when to call them in,
Right.
because nurses can't be there all the time.
Right.
Okay.
There's a core of nurses, and then the usually it's a very small core in nursing homes, and then they call the nurses. Right.
Right. As your qualifications go up, the number of people with those qualifications there diminishes.
Right.
There are more people with less qualifications going all the way up to the most qualified person, which I guess would be the physician.
Right. In a nursing home, all you need is one registered nurse per 8-hour shift per 24 hours.
And if that one registered nurse had to account for the condition and presence or absence of distress for all the residents in there, she would not be there very long. That'd be impossible.
Well, she can't.
Right.
Obviously.
Now, a certified nurse assistant can provide basic first aid, right?
Yes.
And she understands the mechanics of bleeding, what blood is and how that it does flow out of wounds.
Yes.
She would know something about pressure points to stop the bleeding.
Yes.
And she would know something about tourniquets and how they can affect bleeding.
I can't say about that. I don't know whether that's in a basic first aid.
Okay, you don't know.
That's true.
You haven't talked to or looked at these certification records from this state.
Oh, I don't know what they designate as first aid, right?
Are you being paid to be here today?
Being paid for my time, yes, sir. I took
Okay.
a day off from work.
And what are you being paid for? How much?
Well,
it is?
Okay, I charge per hour, but since I'm going to go, looks like 18 hours today, I'm just going to charge a flat fee.
Okay, and so you have a flat fee for a day?
Well, after 8 or 9 or 10 hours, I do, because otherwise, yeah.
Okay, so
for
what
a
is
flat day.
what is your flat fee?
It's going to be flat $2,000.
$2,000. And that's assuming we're done with you today.
Right.
Okay, we hope we are.
I hope you are.
Okay. And does that include, are you staying in any local hotel?
No, I left my home at 4:30 in the morning and flew here. That's why I said it's going to be a long day.
Okay, and did you get any kind of retainer initially?
No.
Okay, so no money was paid to you when you initially got?
Oh, when I did the original review, they paid me. I billed them.
Okay, and what did you bill them for?
I think something like $750, something.
So
like
that's $750 plus the $2,000 for today.
that. Right.
Okay, did you drive up here?
No, I took a plane.
Okay, and
They pay expenses, obviously.
okay, well, what the plane cost?
I have no idea.
Okay, you didn't. They provide you with the ticket. You had the
Yeah,
ticket.
they provide me with a ticket. Let me see if they say on the ticket. It's $98 coming down, $95 going back.
Okay, so that's another $200. So about $2,950, give or take change.
Yes.
Any other expenses that they're going to be billed for?
No.
Okay. And in preparing to come testify, or whatever that preparation consisted of, did you do a report?
No.
Okay. You didn't write anything down?
No, I wasn't requested one.
Okay. And in forming the opinions you testified to up to this point, did you refer to any scientific literature?
Up to this point, no.
That's fine.
Okay.
Is that an honest answer? No.
Yes. Right.
Okay. You didn't read any journals.
Well, it's my own book. I mean, I know what my book is.
Okay.
So, I mean, I guess you could say I refer to my book.
So you wrote the book and you referred to it before testifying.
Yes.
Okay. Did you refer to anybody else's book?
No, I mean, I know of some other articles, but when I gave my opinion, I mean, it's just an article that I think I mentioned to you before.
Right.
But I didn't consult it before. It just happens to I have to be looking at it for another reason, and it just kind of impinges on this.
And I'm asking because I did ask that you bring anything you referred to.
Right, I didn't. I did not, right.
So you didn't, the fact that you brought nothing was because there's really nothing you referred to.
Right, except, what I've written, so.
Okay. I'll pass the witness.
Doctor, you said that by definition, a concussion means you have to lose consciousness. Can you explain that?
Okay, yeah, essentially whenever you get an impact on the head, and there's a transient loss of consciousness, that is called a concussion. And then you have different grades of concussion. From the people who are playing football, you watch the high school football and the kids bang into each other and they one kind of collapses and they get up, to the people who get a head injury and are unconscious for an hour or 2 hours, to the people who get severe concussion and never wake up and just stay in a coma. So it's a transition from very minor to death-dealing injuries.
Now, the prosecutor has asked you whether or not you reviewed any witness statements, and I want to explore that with you a little bit, okay?
Yes.
All right, he specifically mentioned T. Fry and Cleet Jackson, right?
Yes.
Okay, if T. Fry gave a sworn statement to the police that she's now admitted as a lie, would you expect that would have helped you?
No, obviously.
Okay, what if she testified in front of the grand jury not once but twice, is now admitted a lie, and the prosecutor?
Your Honor.
Okay, I'm gonna have to give you some facts because I'm gonna ask you if this stuff would have helped you, okay?
Yes, sir.
And then I'm gonna ask you if that would have helped you.
Yes, sir.
Okay, I'm gonna try to ask this in a non-leading form. If there was a statement that I gave, or a grand jury transcript, where the witness, T. Fry, had admitted to lying and these very prosecutors had to promise not to prosecute her for perjury, do you think that would have helped you?
I don't think so. I think I'd be a little suspicious.
Okay, what if there was a second grand jury transcript from somebody named T. Fry, where she's now admitted that she lied and these very prosecutors had to promise not to prosecute her for perjury for that in exchange for her testimony? Do you think that would have helped you?
No, I don't think so.
What about if I had a sworn written statement from Cleet Jackson that he's admitted was a lie when he testified? Do you think that would have helped you?
Objection, Your Honor, misstatement of the evidence.
Juror will recall the evidence.
Would that have helped you?
No, that's why you try to use objective evidence, because it's not just lying. It's some people lie, but also some people see things differently, or the memory gets scrambled, and so it's always best if you can do something that's objective, that doesn't depend upon human memory, like DNA in rape cases. You want something objective.
Now, let me ask you this. If they asked you about the defendant's statement, okay?
Right. Yes.
If I told you that at the time the defendant experienced these events, she had ingested alcohol, ecstasy, and marijuana, and she had had the added shock of having a 200-pound body come through her windshield, would you think that her recollections of that event would have been particularly helpful to you?
No.
Why not?
Because again, you're talking about somebody who's, if you're under the influence of drugs and alcohol, you're going to have difficulty remembering things. And, especially if it happened at the same time, you're not going to, it's all confusion. Everyone's confused.
We'll pass witness, Sean.
So when we're talking about subjective would be defense counsel's rendition of, as he recalls the facts. That would be an example of subjective. Is that correct?
Right.
Okay. And as far as whether any of this would have been helpful, you never saw it, so you don't know.
That's correct.
It's very possible that some of the truthful parts of all those witnesses' testimony, or even having asked you to watch it on TV, as some people have been doing, while this trial was going on, there could have been details that you would have heard that would have helped answer some questions.
Yeah, but see, I kind of limited my testimony to a narrow thing, and I'm of objective. So I don't know if it would have helped or not.
Okay.
But I was trying to limit it to objective.
I understand. So basically, the opinions and the limits you put on your testimony are not going to be helped by the testimony of the witnesses described?
Yes, sir.
Okay. Thank you, sir. Pass the witness.
Dr. Mile, how on earth would you have been able to figure out what parts were true or not true in an admittedly false grand jury testimony?
Well, that's the problem. I mean, when someone starts lying, when do they start telling the truth? I mean,
No further questions.
Well, Dr. DeMille, with listening to the testimony of another forensic science, do you know Max Courtney?
Yeah.
Do you know his reputation?
Yeah, I've worked.
Okay. Do you know that Max testified in this case?
Yes.
Okay. For a good part of a day.
Okay.
Okay. You don't know what he testified to?
No.
Okay. You don't think Max was intoxicated or high on ecstasy when he did his examinations?
No, but don't forget, no, I don't think so.
Okay. But you don't know what he testified about, and you don't know how it might have impacted your opinions?
That's true.
Okay. Pass the witness.
No further questions, Your Honor.
All right, may this witness be excused.
Your Honor, we'd ask to be released to go back to San Antonio.
That's okay, Your Honor. We'll release him.
Thank you very much.
Alrighty. Holy eyebrows. So, yeah, there's that. And he's one of those people that just like whoever was saying, I bet he is so fun to have like in a hospital setting or just a doctor or whatever. And especially late nights when everybody's joking around and stuff. I guarantee he's a freaking blast. But he's not somebody I want to get in an argument with because I guarantee he is smart as shit.
He kind of reminds me of the guy from Curb Your Enthusiasm.
Yeah.
A little bit.
So I'm going to do something because I can only do it when my mom is not here.
Ooh.
That's the fun part. I'll keep it at 10. So I'm going to set a goal. I really am trying to get a new computer for my mom because she really does need one. So all super chat, super stickers. The goal super stickers don't count towards, like they'll count towards our ultimate goal, but the actual goal thing, it won't let me put super stickers in there, which is stupid. So I'm just going to put AJ's computer fund. But to make this more fun, how Lefko and I play this game, I got a frosty mug and I got several beers. So
is that the same mug that they have in The Simpsons?
It is.
It's just like it.
So most of the time, so this mug takes 2 beers to fill up. So bigger the super chat, obviously it goes towards this. Don't feel obligated. It's just a nice game that we like to play to try to raise some money for my mom's computer. Her computer that she has now can't do what she really needs it to do for streaming. So a lot of times at the moment when you see it streaming, it's actually been me. And so, but we'll go on to the next thing. The next thing is actually closing arguments. And then we'll go on to the verdict, but that does not mean we're done. We won't finish everything today because there's a lot of penalty statements and stuff in there. But what do you mean it's disabled? It better not be
What's disabled?
I'll disable you.
I got it. It says AJ's computer fund.
Yeah. Better not be disabled. I'm ready to go.
Continue.
Yeah. No, it's her computer's about to take a shit.
That sounds horrible. What would that be? Just a bunch of wires all over the floor?
It would be. And then like it's gonna grow eyebrows like this guy has, and then it's just gonna be a lot of, oh, you gotta say the F word because you bleeped yourself out earlier, and even I was like, what? Gabby.
Hmm?
I said you guys say the F word because right at the beginning of the stream you bleeped yourself out.
Oh, I did.
Yeah, we don't do
What
that
the
here.
F?
Close enough.
What the B? Whoops. Sorry. That was
What the
my pen.
corn?
What
Thank
the
you.
corn?
So, all right.
What it do? What it do?
What I do? All right. Well, I'll start. Yeah. Whoever. It's fuck. That's what we're trying to get out of Kathy.
Oh, fuck. Holy fuck. Jeez. Oh, I thought you. I didn't know. My bad.
And yeah, no, you're good. There's no obligation whatsoever to chip into this. I'll drink it anyways. Like I said, just trying to raise a little bit of money for her new computer. Absolutely no obligation. We're just happy that you guys are here and having a good time with us. So without further ado, let's get into closing statements. Share the screen.
Bravo, bravo.
Back on the record. Both sides had a chance to read the proposed court's charge.
Okay, that's right.
Your defense has read it, and we have all the objections we've previously made on the record with the same caveat we made last night about any objections that we haven't made.
All right. Each side's going to have 30 minutes to argue. Has the state wish to divide that up?
Judge, if you'll let me know when I've used 12 minutes, please.
And I'd like a 2-minute warning.
Mr. Kearney.
Give me a 5-minute warning.
Is there anything further before we bring in the jury?
Not from the state.
Bring in the jury. At this time, members of the jury, I'm going to read the court's charge containing the law applicable in this case. In continuing to discharge your responsibilities as jurors, you will continue to observe all the instructions I have previously given to you. These instructions are given to you because your conduct is subject to review the same as that of the witnesses, the parties, the attorneys, and myself. If it should be found that any of you have disregarded any of these instructions, it will be jury misconduct and may require another trial by the jury. If any of you observe one or more of your number violating any of my instructions, you shall immediately warn the violator and caution him or her not to do so again. Please listen carefully as I read the court's charge to you. The original will be sent to the jury room with you when you retire to begin your deliberations. The defendant, Chante Mallard, stands charged by indictment with the offense of murder alleged to have been committed in Tarrant County, Texas on or about the 26th day of October 2001. To this charge, the defendant is pled not guilty. Our law provides that a person commits the offense of murder if she commits or attempts to commit a felony other than manslaughter, and in the course of and in furtherance of commission or attempt, or in the immediate flight from the commission or attempt, she commits or attempts to commit an act clearly dangerous to human life that causes the death of an individual. Our law provides that the driver of any vehicle involved in an accident resulting in injury or death of any person shall immediately stop such vehicle at the scene of such accident or as close thereto as possible, but shall then forthwith return to and in every event shall remain at the scene of the accident and render to any person injured in such accident reasonable assistance, including transporting or making arrangements for transporting the person to a physician or hospital for medical treatment if it is apparent that treatment is necessary or if the injured person requests the transportation. To warrant a conviction of the defendant of failure to stop and render aid in this case, you must find from the evidence beyond a reasonable doubt that the defendant was the driver of a vehicle involved in an accident resulting in injury to another person, that the defendant at the time knew she had been involved in the accident, that she intentionally or knowingly refused or failed to remain at the scene of the accident and render reasonable assistance to an injured person involved in the accident, including transporting or making arrangements for transporting such injured person to a physician or hospital for medical treatment, and that it was apparent that the treatment was necessary. If you should have a reasonable doubt as to the existence of any one or more of such matters, you would be bound to acquit the defendant. The term individual as used herein means a human being who has been born and is alive. Act means a bodily movement, whether voluntary or involuntary, and includes speech. Omission means failure to act. Deadly weapon means anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death or serious permanent disfigurement or protracted loss or impairment of the function of any bodily member or organ. A person acts intentionally or with intent with respect to the result of her conduct when it is her conscious objective or desire to cause a result. A person acts knowingly or with knowledge with respect to a result of her conduct when she is aware that her conduct is reasonably certain to cause a result. Voluntary intoxication does not constitute a defense to the commission of crime. Intoxication means disturbance of mental or physical capacity resulting from the introduction of any substance into the body. Now, therefore, if you find and believe from the evidence beyond a reasonable doubt that the defendant, Chante Mallard, in Tarrant County, Texas, on or about the 26th day of October 2001, did then and there intentionally or knowingly commit or attempt to commit a felony, to wit, failure to stop and render aid, as prescribed in Texas Transportation Code 550.021, which is captioned accident involving personal injury or death, by being involved in an accident resulting in injury to or death of Greg Biggs, and failing to immediately stop her vehicle at the scene of the accident or as close thereto as possible, or then returning forthwith and remaining at the scene of the accident and providing to Greg Biggs reasonable assistance, including transporting or making arrangements for transporting Greg Biggs to a physician or hospital for medical treatment if it was apparent that treatment was necessary, and in the course of and in furtherance of the commission or attempt, or in immediate flight from the commission or attempt, she committed or attempted to commit an act clearly dangerous to human life, to wit, transport Greg Biggs to her home when he was seriously injured and lodged in her car or lodged in the windshield of her car, and she secreted him in her garage, which prevented him from receiving medical care, which caused the death of Greg Biggs, as charged in count 1 of the indictment, then you will find the defendant guilty of murder. Unless you so find and believe from the evidence beyond a reasonable doubt, or if you have a reasonable doubt as to whether the defendant is guilty of murder, you will acquit the defendant of murder and next consider whether she is guilty of failure to stop and render aid. Now, therefore, if you find and believe from the evidence beyond a reasonable doubt that the defendant, Chante Mallard, in Tarrant County, Texas, on or about the 26th day of October 2001, did then and there intentionally or knowingly, having been involved in an accident resulting in injury or death of Greg Biggs, failed to immediately stop her vehicle at the scene of the accident or as close thereto as possible and return forthwith and remain at the scene of the accident as provide Greg Biggs reasonable assistance, including transporting or making arrangements for transporting Greg Biggs to a physician or hospital for medical treatment if it was apparent that treatment was necessary, then you will find the defendant guilty of failure to stop and render aid. Unless you so find and believe from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will acquit the defendant of failure to stop and render aid and say by your verdict not guilty. In a criminal case, the law permits the defendant to testify on her own behalf, but she is not compelled to do so, and the same law provides that the fact the defendant does not testify shall not be considered as a circumstance against her. You will, therefore, not consider the fact the defendant did not testify as a circumstance against her, and you will not, during your deliberations, allude to, comment on, or in any manner refer to the fact the defendant has not testified. A person is criminally responsible if the result would not have occurred but for her act, operating either alone or concurrently with another cause, unless the concurrent cause was clearly sufficient to produce the result and the act of the defendant clearly insufficient. A person is nevertheless criminally responsible for causing a result if the only difference between what actually occurred and what she desired contemplated or risked is that a different offense was committed. You're instructed that unless you believe from the evidence beyond a reasonable doubt that the alleged confession or statement introduced into evidence was freely and voluntarily made by the defendant without compulsion or persuasion, or if you have a reasonable doubt thereof, you shall not consider such alleged statement or confession for any purpose, nor any evidence obtained as a result thereof. All persons are presumed to be innocent. No person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at her trial. The law does not require a defendant to prove her innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after a careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these written instructions, you will acquit the defendant and say by your verdict not guilty. You're instructed that the indictment in this case is no evidence whatsoever of the guilt of the defendant. It is a mere pleading necessary in order to bring this case into court for trial, and you will consider it for no purpose. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and the way to be given their testimony. But you are bound to receive the law from this court, which is herein given you, and be governed thereby. After you retire to the jury room, you will select one of your members as your presiding juror. It is his or her duty to preside at your deliberations, vote with you, and when you have unanimously agreed upon a verdict, to certify your verdict by using the appropriate form attached hereto and signing the same as presiding juror. You are instructed that your verdict must be by a unanimous vote of all members of the jury. In deliberating on this case, you shall consider the charge as a whole, and you must not refer to or discuss any matters not in evidence before you. Neither shall you separate from each other, nor talk to anyone not of your jury. If the jury wishes to communicate with the court pertaining to this case, such communication must be in writing, signed by the presiding juror, and handed to the bailiff, signed by myself, James Wilson, Judge of the 371st District Court. Last page is the verdict form. We, the jury, find the defendant, Chante Mallard, guilty of the offense of murder as charged in count 1 of the indictment, placed for the presiding juror. Or, we, the jury, find the defendant, Chante Mallard, guilty of the offense of failure to stop and render aid, and placed for the presiding juror. Or, we, the jury, find the defendant, Chante Mallard, not guilty, and a place for the presiding juror. Charge on count 2. The defendant, Chante Mallard, stands charged.
Y'all want me to fast forward through this? Let me know in the chat, because I can. Hi, Puddleton.
Oh, do we have to? Do we have to watch the jury instructions? Does anybody want to watch them?
Heck no, we don't have to do that.
That's what I'm saying. I mean, if someone really wants to watch them,
then they can go to courttv.com.
I just feel like.
So, all right, you guys are I'm gonna let y'all talk to Gabby for just a second. Or
Frank said no. Frank is the one who chose.
Yeah,
we're gonna blame Frank here.
All right, so yeah, everybody's saying no. All right, I'm gonna let y'all talk to Gabby for just a second. I mean, I'll still be on the screen. I can still hear you guys, but I'm gonna take this off the screen while I try to figure out where this actually gets into closing arguments.
The argument over them is sometimes interesting. It is, but sometimes, you know. I like this one. No.
Can you hear that if I'm playing it? My brother.
Hey,
What's
super
up?
son.
You're supposed to be with our mama and our papa.
Papa.
All right, super son.
Cheers.
It's damn near full. You're gonna have to drop that super chat. Oh, just kidding. Let's go. Just kidding.
Oh.
Be a shame
Yeah,
if you to go.
about me now.
I'm gonna get full.
What did he say about me now? Something about Busch Light? I don't drink beer. I'm a real man. I drink rum. Busch Light.
I look like a 12-year-old boy. I'm a 30-year-old woman. I'm just waiting for my
No,
balls to drop.
you look like you should be in a high chair with that thing. That thing's bigger than your head. Like you need extra support to so you don't fall over holding that thing. That thing is giant.
That made me spit it out.
Would be a shame if you neglected some Busch Light and Gabby ended up in the Boston Tea Party. How you doing?
Stop making me laugh, because I gotta do something I never do, which is open my throat.
Oh, you know what they
Stop
say.
You're making too much air going.
Come on, Carmen. Open it up. Open it wide. You got this. You got this.
Stop making me laugh. Stop making me laugh. Damn it. You got an air pocket in my stomach.
I got an air pocket in there? I don't know. I think you need throat opening skills.
I do. I'm gay as fuck.
I mean, I would say, never mind. I'm not even going to say it.
I gotta do this for him. Stop making me laugh.
All right.
Not feel like I'm just on the air.
I mean, how are you even lifting that glass? Is your arm strong enough to lift that? You got someone underneath pushing your arm up for you. There you go. Perfect throat opening skills. Awesome.
I didn't mute myself. Anyways, talk to Gabby while I figure this out.
You already said that like 3 times. Ash. She's just like... That's funny. Is Boston... Is the word YouTube was rejecting maybe the baseball game? I don't know. YouTube just be rejecting whatever the heck they want nowadays. I could just say the word "the" and it'd be like rejected. I'm like, really?
I said camo not too long ago.
Oh yeah, I said the word blender. Like I was talking about blending fruit to make a smoothie, and it wouldn't let it through. Ridiculous.
I did. I don't have a drinking problem, but I did spill some right on my shirt.
That's alcohol abuse. I'm just saying that.
Yeah. Beer fest, everyone. Hey, it's beer fest for mamas trying to raise some money for a new computer. So, because unfortunately, I'm gonna give you guys
beef curtains. Sorry.
I'm gonna give you guys a little insider. I will no longer be with you guys here shortly. That sounded suicidal as fuck.
Yeah, I was just gonna say, like what, within 5 minutes, or what are we talking here? Like
that sounded really bad. No, I have some things. I ended up switching departments, so I went from federal and actually dropped it down to local. So, I just feel like it's in my best interest. It's not because I'm scared of what's happening with federal and what's happening with ICE. That has nothing to do with it. It was within my facility that I worked with that I thought this was the best decision to make.
Hey,
so
Sticky.
That's what I'm doing. Yesterday, when I had a stress headache, it was because I had my psych eval, and a polygraph test, which it's not that I have any concerns with that. It's just, it's not fun to take it. And so that's why I'm trying to give you guys some fun tonight, because I don't know what the next couple days hold.
Yeah.
But we're gonna have some fun. What's up, Sticky?
Sticky stick.
Who is calling me? I want to talk to you.
Who is that? Your mom?
No. No. No.
I'm just kidding. Oh my god. I have to say that. I know because I know she's either watching this now or gonna go back and watch it. So it'll be funny.
Well, obviously they're done with dinner because my brother's in the chat.
Oh man.
She's probably sitting there like, what the hell? Sitting there chugging beer, doing super chats, saying the F word, making people say fuck.
Yeah, but the way I say it, YouTube won't even understand what's even happening. So that's fine.
Yeah. I don't give a shit. Like,
I mean, I give -0 shit, so.
I don't know what my hair looks like Johnny Bravo today. I think it's the way my headphones is laying it down. It's just like swooped over.
Yeah, it's got that little swivel at the top. It's got that little it's like a cow just came over and just gave you a little cowlick right in the front. It's like your hair is from Dairy Queen. It just got that little twist at the top.
Go fuck yourself.
I mean, all right.
I'm just joking. All right, guys. We got
back.
We got 7 super chats.
Yep.
I'm gonna say 6 super chats because I'm gonna count Gabby's super sticker. For whatever reason, they will not count super stickers, which is stupid. Until we get to a goal, any little bit counts. If it's even like 99 cents, it still counts.
I actually tried to send a super chat first, but it rejected it.
It rejected it. It was doing that to me in Grandma's chat.
Yeah, it's been doing that to me too. And I'm like, YouTube is just like the worst lately.
Because it did that to me. It did that to my brother.
Yeah. It says, don't worry, you weren't charged. I'm like, well, great. But then if you go to resend it, it says you already own this super chat. I'm like, but you just said.
Yeah, no, it's been a pain in the ass. So, I mean, if it lets y'all send something, and if you want to send something, great. There's no obligations. Like I said, we're here for you, and we are happy that you are here. I'm sorry if I feel like my voice is shaky. I am freezing cold because this room is cold, and I really need to go get a
sweatshirt. Go get your ballin' sweatshirt. Go get your Purdue chicken sweatshirt. I don't know what that thing's from.
The thing's
there you go. Yep, YouTube is being rude.
It is. Thank you so much, Ash. But yes, YouTube is being rude.
Purdue usual.
Don't even support Purdue. I mean, my brother graduated from Purdue. Cheyenne graduated from Purdue.
Oh, it's a real place? I didn't know. You're just fucking with me.
It's a whole university. And there's Purdue chicken.
I thought you were messing with me. My bad.
No.
That's even more hilarious. Oh my god.
No, we had like I'm glad you're sitting in front of the AC. No, we had like it was like 100 here last week, and then it dropped 20 degrees, which it's only in the 80s, but then it's dropping in the 60s and 50s at night. 80s. So
I'm like, today was like 70, 74 here.
Yeah, no, it's been going from like 100 all the way to the 60s. So
and right now it's 55. It's beautiful right now.
55
makes
me want to throw up.
Love me some sweater weather.
I hate sweater. I hate it. I hate snow. I hate I just
I
want
love
to.
me
I just want
some.
to bake in the sun.
Love me some good hoodie weather. Love it.
No, thank you so much, Frank. We really, really appreciate it. Also, if you guys could, it is Gabby's birthday month. I hate saying that because I think that's gay. And I can
Yeah,
say
why'd you do that? God damn.
I am gay. I was born
Yeah, that's
on
true.
Halloween. Yeah, I can say it because I am gay. Gabby was born on Halloween, so it's her birthday month. So make sure you guys give her some shit. The rowdier, the better in my books. I got in
Thanks,
trouble
Carmen.
last time for saying that you can't be rowdy when my mom's here. So you know what? When she comes back tomorrow, I hope you all are your rowdiest self.
Well, I mean, you can be rowdy with AJ. She'll just pull up your chat and just shake her head at you. And then but
Yeah.
she knows it's funny.
Yeah.
Thank you, Ash. Thank you for that. Yep. Halloween
Why'd
is
you
my
sound like-
birthday.
Why'd you sound like a man when you said thank you? Thank you, Ash.
I don't know. I was about to like burp, but I had to hold it in because I was talking. So that's why like my voice got one octave deeper. Thank you, Ash. Thank you. I sound like
guys.
a damn friggin' cotton candy behind you.
It's my
I
gayness.
can't. All right.
It's my royal gayness. Just
It keeps changing colors, right? Like I'm not imagining this.
no, it does. So
Okay,
it gets off
yeah.
beat. It gets off beat sometimes, but it'll correct itself. But
What happened to you? Your walls were changing color, whoever? Or
No, my freaking lights. These things.
yeah, I like
These
them.
are changing. They're changing colors. Also,
I
if
like
you want
them.
to get them, they're $20 on Amazon.
I think they're cool.
Yeah, and they'll change colors, they'll strobe, and then
No, we don't want anything strobing. There's enough strobing in chat. We don't need anything else strobing.
And this thing, which I have right above my head, or not right above my head, right above my camera. It's an additional $4. It's got
If you did have it above your head, it would look like a halo, though.
yeah. It's got a bunch of different lights on it. Like you can go through them.
Oh, was that the thing you were doing the other day?
Yeah, this is what I was doing the other night. Which was that one.
Yeah,
That one.
stop it. I don't like it.
So
I don't like it for you. So shut it down.
yeah, that's fine. I'll take my medicine. But anyways, guys, we'll get back to the stream. So
Yeah,
this is
enough of-
closing arguments. Lady that we called just got off a motorcycle. This is the first one. Up
Share the screen, Carmen. Turn the sound on, Carmen.
I'm just trying to pee. Jesus
Me too. I was just about to get up and I was like, share the screen. And then I heard nothing. I was like, share the sound.
My apologies. I'm so sorry. Inches away.
Yeah, buddy.
It was dark. It was dark. And when Chante Mallard shut off the light, closed the door, and left him to die, for Gregory Biggs, it was the darkest night of all. Ladies and gentlemen, the judge gave you the instructions, and he just read them to you, and you'll be entitled to take them back to the jury room. With regard to the murder charge, you will find two offenses in here: failure to stop and render aid, and murder. And let me make one thing clear.
before you ever even reach the issue of simply failure to stop and render aid, you must all 12 believe that she is not guilty of murder. And ladies and gentlemen, how do you know that Chante Mallard is guilty of murder? Let's look at what we have to prove. Richard talked to you in voir dire, and he said, in order to be guilty of felony murder, you must commit a felony, and then you must simply do an act that is clearly dangerous to human life. Well, you know from all the evidence what felony she committed. Failing to stop and render aid. You know that. And what did she do on top of that? What did she do that was so much more than failing to stop and render aid? She pulled over, and you saw from the maps the area that she pulled over in. And how do you know that she pulled over? From her friends, her associates, the people with whom she chose to surround herself. And they told you she stopped and pulled over and tried to get him off her car. And in that moment, she made many decisions. And in that moment of clarity, she made a choice. Less than half a mile away from phones. And you saw the pictures of all the phones. Less than half a mile away from a fire department. A place that she would know better than anyone the help that Mr. Biggs could receive. The emergency medical attention that was available. And you know, if she pulled over into that industrial area, the street right next to that is Wilbarger. So she made one of two choices. She either drove past the fire station or she drove away from the fire station. Further evidence of her choice to conceal Greg Biggs from anyone who would ever help him. And how else do you know that Greg Biggs was still alive in her house? You know from her own words to Detective Owings. And you're going to be given an instruction in this charge that says you must believe that this statement was voluntarily given to believe it and to consider it as any evidence. So let's talk about what the law is regarding statements. The law says that a defendant must receive the Miranda warnings. They simply must be read, and the defendant must understand them, and the defendant must waive them and agree to speak to Detective Owings. And you know that that's what happened. You know that not only was she read her warnings, but she was shown them in writing. And you know that not only did she agree to waive them, but she memorialized that and signed that and initialed every single right that she had. And this is not an uneducated woman. This is not someone with a mental disability. This is someone who, based on her resume, has been to college. She has more education than most people. She understood her rights, but she wasn't just given them once. She was read them on her statement, and she read them again when she read her statement. 3 different times she received her warnings. And ladies and gentlemen, make no mistake about it. You will never find on these warnings, and if you choose to call your brother, the police must stop the interview. That is not the law. This is not a family reunion. It is the business of prosecuting crime. But how else do you know that her statement is her words? Look at what it said. Look at her words. Look at the choices. Count the number of times she uses the word sorry, the number of times she uses the word scared, the number of times she uses the word terrified. And counsel for the defense in opening statement said 31 minutes. Detective Owens had 31 minutes with the defendant. Folks, this statement wasn't 31 minutes in the making. This statement was 4 months in the making. She had 4 months to contrive what she was going to say to the police. And look at what she said. Counsel wants you to believe that she was panicked, that she was so upset, that she was crying. Well, amidst her tears, she found the ability, the wherewithal, the presence of mind to lie to the police. She lied about being at T's house and coming home from there. She lied about the number of drinks she had. She lied about smoking pot. And she lied about taking ecstasy because she said someone put something in her drink. She minimized her involvement. She put herself in the best light. And what else do you know? She lied about who helped her move the body because she said someone simply named Vaughn. This is a man Miss Mallard had a relationship with. This is the man Miss Mallard was intimate with. This is a man Miss Mallard knew his last name. She lied to the police. She had that presence of mind because once again, Miss Mallard was in the driver's seat. And if this is her version of the best light, doesn't it speak volumes? Because in this statement, the least of what she admits is that Mr. Biggs was still moaning. That he was still moaning. But you know that he was alive from the physical evidence, the expirated blood in the console. And you recall Mr. Courtney, who showed you the direction of the blood. But it was like this. Isn't that absolutely consistent with Mr. Biggs leaning over the dashboard, struggling to breathe, struggling to live, and coughing up blood? But that's not all. Because over here on the door panel, you have the contact blood on the outside of the door panel and the most compelling evidence on the inside of the door panel. He was holding on to the door. And you know what else? When you look at the pictures of how he was found in Cobb Park, his hand wasn't found like this. His hand was found like this. And you know that rigor sets in when you die. So not only had he put his hand inside of the door pocket, but he'd been able to move it out. He was alive and moving in that car. And how else do you know that she is guilty of murder? Because all of the medical evidence tells you so. Jim Satter tells you, I could have saved his life. There isn't a fireman in Fort Worth who couldn't have saved his life. Ray Swinton, who got up here and gave you a clinic on emergency medicine. A man who was an EMT, a paramedic, and finally, the chief physician at John Peter Smith Hospital. We could have saved his life. Nizam Pirwani, a quarter of a century in forensic pathology. He could have been saved. And even Dr. DeMaio said he could have been saved. The evidence is overwhelming, ladies and gentlemen. The physical evidence supports it. The defendant's confession supports her guilt. Her admissions to her friends support her guilt. Ladies and gentlemen, I ask that you find the defendant guilty of murder. When she took him home to her garage and concealed him from anyone who would ever render aid, she guaranteed his death. Thank you.
Good morning. Good morning. You know, we all have enormous sympathy for Gregory Biggs' family, his son, for the loss that they've suffered and the sadness, the true sadness that they must feel. We all do. And there's no question in this case that Chante's failure to render aid or call for assistance probably caused his death. There's no question about that. But that's not murder. And that's what this case is really all about. See, this part of the case focuses on you, each and every one of you individually and collectively. This is your part of the case. This is when you decide and tell us whether or not this is murder. And the judge tells you how you go about making that decision. And what his honor tells you is you must follow the exact letter of the law. And if you do that, your decision-making process will be pretty easy. And if you follow the exact letter of the law, your verdict will be true. But if you let your decision be influenced by sympathy, by media coverage, by emotion, your decision-making process will be difficult, and your verdict will forever be compromised. And that's why we have you here. Because, ladies and gentlemen, you, each and every one of you individually and collectively, have enormous power. You have more power as a group than any group sitting anywhere in this country right now. Your power is unlimited because you have the power to decide whether or not Chante Mallard is guilty of murder, a decision that will have drastic effects. And that's a great deal of power. And with power comes responsibility. And you have your responsibility in this case is clear. Your responsibility is if we're going to do this right, and if this is worth doing, you have the responsibility to make that decision based exactly on the law as His Honor Judge Wilson gives it to you. And that's your responsibility. And I know it's a serious responsibility, and I know you will take it seriously. Because whenever power is exercised in any civilized society, it must be exercised with responsibility. It must be responsibly exercised for it ever to have any meaning, for it ever to have any lasting value, any power that any government has, or any group that the government gives power to, like you. For that power to have any meaning, it must be exercised responsibly. And I know that you will. But under our law, ladies and gentlemen, the government, the prosecutors have a responsibility. And their responsibility is that if they're going to ask you to exercise the power that you have and convict Ms. Mallard of murder, that they have a responsibility that they bring you clear, convincing, reliable proof beyond any reasonable doubt to prove each and every one of those elements that His Honor Judge Wilson tells you in those instructions. And that's their responsibility. And if they don't do that, that's not your fault. That's not your fault at all. If they don't do that, the judge tells you very clearly in his instructions that you must vote not guilty. You see, ladies and gentlemen, the law places you. It places you between the government and the citizen accused. And there's a definite reason and purpose for that, because the law doesn't let them make the decision about whether or not Chante is guilty of murder. They're too close to it. They're too involved. The government prosecutors don't get to decide that. That's why we have you. If you just accepted their version of what happened without making an independent determination in each and every one of your own minds and in your own heart and in your own conscience, if you just accepted their version, we wouldn't need you. That's why you're here. You're here to test the quality of their proof, to test if what they claim is really true under the evidence and under the law. And just because they claim it doesn't make it so. It only becomes so if you have made an independent determination in your own mind what this evidence shows and how this law should be applied. They don't get to decide. You do. And the genius of this law, I mean, this is an incredible law that places a jury in between the government and a citizen accused in our country. And the genius of this law has never been more evident than it is in this case. Can you imagine a case where a jury could ever be more important? This case has had incredible media coverage, incredible community pressure, incredible negative coverage. And if we just let the media and the community pressure and the prosecutors decide cases, we wouldn't have a system. And that's why this law is evident. And the importance of it is evident in this particular case. Because what we have in this case, ladies and gentlemen, is what we've had is a media feeding frenzy out there. And it's human nature for prosecutors and all of us to try to feed that media monster. This is what the media is calling out for, so let's do it. You can't be on television, and you can't have cameras without that affecting you in some way. But His Honor Judge Wilson says it can't, because if we're going to do this right, you can't let that have any effect on you. It's human nature that it will. It's human nature that it will affect the prosecutors. It's human nature that because we're on TV, we have recreated cars coming into our courtroom and digital, photographs and images flying all over this courtroom. It affects all of us. I can tell you it's affected me. I've made some decisions in this case, and in the back of my mind, I go, I wonder what the commentators are going to say about that on TV. Are they going to criticize me? And I have to shut that down because I have to make the decision that's right in this case. And so do you. You have to make the decision that's right in this case based upon the law and based upon the evidence. If you believe this is a good law and you believe this law of the jury system is worth keeping, please do what you require in this particular case, and we will be able to keep this law. You know, ladies and gentlemen, we are a society of laws, not a society of men. What does that mean? What that means is that in our society, we have to make decisions in our judicial system based upon law and not based upon how men or the community feels. We're a society of laws, not men. And because of that, even the most publicized case should be treated the same. Even the most notorious case has to be treated the same under our law. Because we can't let men come in and say, this case is so unusual, this case is so sensational, that we need to kind of change the law a little bit in this case because our community is crying out for it. The media is crying out for a decision that they all want. So in this case, we'll kind of change the law a little bit. Well, that would be a law in a society based on men and individuals, and we don't have that. You have to follow the law in this case, because if ever a jury at any time in our country, if you're ever convinced to base a decision on something other than the law, we lose a little bit of that precious liberty that we call freedom. So if you're allowed to be convinced in this case to base your decision on anything but this law, we're going to lose something very, very valuable to us, and it will slowly erode and go away. Why is this case right now about you? This case is about you because you are the exclusive judges of the credibility and believability of the witnesses in this case. You now have become judges. And when you walk back in there, Judge Wilson tells you the law and you will follow it if we're going to do this right. And number two, you get to judge the witnesses. And how much believability or credibility do they really have? And I want to talk to you a little bit about some of these witnesses. I want to talk to you about one that they keep relying on. And every time they get up and say something, well, the evidence showed this and the evidence showed that, 99% of it is what they're telling you that T. Fry said. Okay? So when they say that to you, the evidence says this and the evidence says that, say in your mind and ask each other back there, who said that? Let's identify who it is, and let's identify whether they're credible. Don't just say, oh, the government said it, so it's okay. Don't do that. Sit back there, and one of you, please, speak up. Speak up and say, I want to know who said that. And let's see if that person is credible. And if you can't decide who said it, write a note to His Honor Judge Wilson and say, we have a dispute about this fact. We want to know it. And write a note and send it out, and the court reporter will give you the answer back. That way you'll know who said it and you'll know whether you can judge the credibility. Because when we're talking about T. Fry, that's extremely important. Who is she? Let me tell you who T. Fry is. T. Fry is someone that these prosecutors brought before the Tarrant County grand jury. And when you go into the grand jury, you sit in a stand just like this, and you raise your hand, and you tell 12 grand jurors sitting very much like you are that I swear to God I'm going to tell you the truth. And she went into that grand jury, and these prosecutors told you that she lied and lied and lied. And she left that grand jury, and they brought her back in months later. And they bring her back into the grand jury, and she gets in the grand jury again, and she raises her right hand, and she swears to those people, just like she did to you, that she's going to tell the truth. And they say she lied again under oath. And they took a statement, a sworn statement from her, where you swear in front of a notary that you're telling the truth. And she lied again. And so what do these prosecutors do with this liar? A person who's committed aggravated perjury and lied to 12 citizens just like you? What do they do to her? They come to her and they say, I tell you what, you're a liar, you've committed aggravated perjury, and we're going to prosecute you and send you to the penitentiary. Or you can be a witness for us. Now, does that make much sense? We're either going to send you to the penitentiary for lying, or we're going to make you a witness and have you get on the stand and testify for us. And that's not a hard decision for someone like T. Fry to make. I mean, you can be a defendant and go to the penitentiary, or you can be a witness. I mean, that's a no-brainer. And so what do? They take this magic wand that they own that we don't have. They take this magic wand, and what they say to her is, we're going to wave it over you and give you immunity. And by us waving this magic wand over T. Fry, the liar and the perjurer, now they claim is a truth teller. People don't change their spots like that. T. Fry, who they hunted down and said, we're going to send you to the penitentiary, is now their spokesman. She comes with a warning label, ladies and gentlemen. That's right. If you use anything she says, it could be hazardous to the truth. And I'm going to tell you what, ladies and gentlemen, if you swallow anything she says, it's going to poison the truth. So please, somebody raise your hand and say, now, who said that? And let's see if we think they're credible. Because there's no way with her history that she can be credible. And you ought to be disgraced that they bring her in here when they've accused her of lying 3 times under oath and ask you to believe she's telling the truth. You ought to be incensed. You ought not believe a thing that she says. And don't let them come in here and say, oh, we don't get to pick our witnesses. The defendant picks these witnesses. But when they say that, I'm going to tell you what they're saying to you. If they say that to you, what they're saying is very simple. They're saying, let's lower the standard of proof because our witnesses aren't very believable. Let's don't hold these witnesses to the same standard. You tell them, no, we're going to hold every witness to the same standard. And if you do that, you can't believe a word she says. Now, let me talk about a different way to judge credibility. They brought this Max Courtney, the blood man in here, and they assembled this car, which I'm going to tell you what is a total distortion of what the inside of that vehicle looked like. And there's a reason they did that, because they want you to look at this and say, look at all the room in there. Well, the true car has no room like this. The dashboard comes right there, and you've got some pictures. You've got 3 big pictures of a red car just like this. And take them back there and look. And don't be fooled by this distorted view of how much room is in the passenger compartment of this car, because it's a total distortion. Number 2, talk about Max Courtney's testimony. He comes in here and he claims he's a blood expert, but what does he tell you? He's been to 4 little one-day courses, and one of them he taught himself in. And that's his experience in blood spatter evidence. But he comes in here and he claims to be an expert, and what does he tell you? He owns a forensic lab, and he does. And they do quality testing on hair fibers and stuff like that. And what he comes in here, in order for their theory that this prosecutor just made an opening statement, Ms. Jacks, their theory that his head was here, his hand was here, and for all that to work, you know what we have to have? Remember, he said that there was smeared contact blood right here, and that's where he found the hair, okay? Remember that? There was a hair found right there. And based upon that hair found right here, his proposition, his speculation, his guess, is that the man's head hit right here because there's hair, and that's where his head was when he claims this blood was expressed into the console. Okay? Now, why is that important? This is how you know that what Max Courtney tells you can't be relied on. I'm going to tell you why. Because we asked a question. Reagan asked the greatest question in this trial. He said, Mr. Courtney, is that a head hair or is that a body hair? I don't know. And Mr. Quinn asked Mr. Courtney, he said, Mr. Courtney, isn't it true that you can run a simple test and test whether that's a head hair or a body hair? And he said, yes, we can. And isn't it true that your very laboratory, which is right over there in the hospital district in Fort Worth, that your very laboratory can run that test quickly? Yes, we can. But I don't know. Why doesn't he know? Wouldn't it be nice to know? Don't you think they're smart enough to know? Don't you think they're smart enough to run that test? Sure they are. Why do you think they're not running that test? Why do you think it's been 3 days since Mr. Courtney's been in here and that test still hasn't been run? Why do you think so? Because they want you to buy this proposition that the man's head was right there. They want you to buy that. And if that hair is a body hair, none of it works. This is a total corruption of the theory, don't ask, don't tell. Because they could ask and they could tell, and who knows if they know or don't know, but one thing we know is you don't know. And if you don't know the answer to that question, you cannot rely on some extravagant demonstration that a hand was here and a head was here. You can't rely on that because we don't even know if that's a head hair. Don't ask, don't tell. Sometimes you don't ask and you don't tell because you have the answer. But you don't, and you can't rely on it because I'm going to tell you one thing. We're not to the point in this country where we start guessing people in the penitentiary. We're not to the point in this country where we start speculating and putting people in the penitentiary. And how many times did Mr. Courtney say, I don't know. I don't know how it got there, but I can't imagine another way. How would you like to go home and tell your neighbor, well, I sent somebody to the penitentiary because the expert said, well, he can't think of any other way it could have happened. That's exactly what he said. Your neighbor would say, you're crazy. Don't buy into this. Don't buy into this. Please don't. And then Detective Owings. Let's talk about that. Ms. Jacks talks about this statement. Let's talk about that statement. What do we know about Detective Owings? He's a 27-year veteran, skilled interrogator. He is a supervisor. He was running 14 police officers out that day. He was in charge. They planned what they were going to do ahead of time. He planned what he was going to do ahead of time. He planned he was going to go in there and get Ms. Mallard and take her to get a statement off of her. He already knew that. He took Detective Johnson, the female detective, with him. And by taking Detective Johnson with him, he took her because he was going to handle a female. And then when they left the house, and they took Ms. Mallard down. When they left the house and they took Ms. Mallard down to the police station, they took Detective Johnson with him. And we said, why, officer, did you do that? And he said, I took her because I was handling a female and we need to have her be with us, be a witness. And he takes Ms. Mallard down and no question about it, she was crying and she was upset. And those are the detective's words, not mine. Crying and upset, and he takes her into a room, closes the door, and sends the female officer out of the room. Why? You take her all the way out to the house. You have her ride all the way back with you to be a witness. And then you send her out of the room, and we have a 31-minute period of time when nobody's in that room but that trained interrogator and a 25-year-old woman who is upset and crying. And what did Detective Owings know before he walked in that room? What Detective Owings knew, and all he knew, was this Miranda Daniels version of what happened, the one that hit the press early on, the one that has proven to be absolutely untrue. And he knew that version is the version he was going by. And you'll see in that statement of Ms. Mallard that a lot of what Miranda claimed ends up in that statement, not what Ms. Mallard claimed to Detective Johnson. And because he had this preconceived idea of what the story was, that gets into this confession. And you know what? I can tell you that the Fort Worth Police Department's got to have 150 or 200 tape recorders. I can tell you, and Detective Johnson told you, that you can, and the law says you can and should tape record statements, and he didn't tape record it. And you know he was trained as a police officer to take notes and detailed notes. And he's never had a case this important. This is the most important case he's ever had. And do you really believe he didn't take one note for 31 minutes when he was trained to do that for 27 years? Come on. Come on. And that's why, if he wanted a witness to what was happening in that room, he had Detective Johnson, a female. And we know she didn't have anything else to do. We know she was dedicated to this job that day. And we know what she did. She sat in the hall because he wouldn't let her in. And why? And so when they start saying, Ms. Mallard said this in her statement, Ms. Mallard said that in her statement, I'm going to tell you what, you need to think about the conditions under which that statement was taken and how reliable you really think that is. Because I think if you give it an honest look, you'll get an honest result. Now, let's talk a little bit about the charge and what the judge is going to tell you. Because what the judge is going to tell you in this case is, number one, is that before you could ever convict Ms. Mallard of murder, she has to commit an act that causes his death. Page 2 of the judge's instructions tells you this. And I'm going to tell you what, they're going to give you one set of instructions back there, but I hope that y'all will knock on the door or push that buzzer and say, give us 12 sets. So everybody will have one, and we don't get one person back there saying, well, this is what it says, Ask for 12 copies of it. Ask the judge to give you 12, so everybody will know what it says. An act means a bodily movement, okay? That's what it means, a bodily movement. And on the same page, they tell you an omission means a failure to act. A failure to act. What did Chante Mallard do? What caused Mr. Biggs' death was the failure to call for medical attention, not any act. Page 3. His Honor tells you that the act, and it has to be an act, it can't be an omission, must cause the death. It has to be an act clearly dangerous to human life, you see that in red, which caused the death. And he tells you if you don't believe it's an act, or even if you have a reasonable doubt about that you shall resolve that doubt in favor of Ms. Mallard and say by your verdict not guilty of murder and find her guilty of what she's really guilty of, and that's failure to stop and render aid. The next thing we have, these are the acts that they have to prove. These are the only 2 acts that they can prove to support a conviction for murder. These are the only 2. That she transported him to her home when he was lodged in her car or windshield. They have to prove that, okay? On the second one, that she secreted him in her garage, which prevented him from receiving medical care. All right, now look at that carefully. Secreted him in her garage. Look at the second clause of that, which prevented him from receiving medical care. Thank you. And they have to prove that beyond any reasonable doubt. Why is that important? Because they have to prove one of these 2 acts actually caused the death. And if you believe that the failure to act caused the death, it's not murder. It has to be the act that caused the death. Look at this. Secreted him in her garage, which prevented him from receiving medical care. Think about this, and this will really help you, I think, going through this process. It'll really help you. It says, which prevented him from receiving medical care. That means that these prosecutors have to prove to you beyond a reasonable doubt that if Miss Mallard hit him and stopped right on the side of the road, pulled over on the shoulder, and she gets out and wanders off in a daze, they have to prove to you that he would have received medical care at 3 o'clock in the morning out there on the side of the road.
So what do you guys think about this so far? Sorry that I keep pausing. One, I had a phone call, and two, my dog keeps howling. And Cheyenne's in clinic right now, so I need him to not do that.
Well, I'll tell you what I think. Fact.
Back what?
That's it. That's what I think. It's fact.
Oh, I thought you said back. I was like, back
No.
what?
I said it's fact.
Yeah. Whoever says, I think she's going to get found guilty. Yeah. Yeah. And then the judge's hair looks a little bit like my brother's.
Every time I look at the judge's hair, I just want to like trim it, just
Yeah.
like right in the
It's-
middle,
Yeah. Like with
just like a little patch,
the dude that testified before him, I just want to like just cut that little section off of this guy.
Yeah.
Just match it up.
No, Ash, you didn't get the hammer. It's YouTube. YouTube is just acting a fool.
Yeah, I mean
Tonight.
YouTube Daddy is on his period right now. Everybody's getting a hammer.
They're man-straighting.
So yeah. So, but I do apologize for having to go off stream. I had a phone call that I had to take, and then my dog, like I said, keeps howling. So we can't have that. Yeah, my brother isn't a hair cutting so much. I shave my head on the shortest clip setting because I don't mess with hair. Hey, I don't blame you. But we got
My hair is so long. I need a haircut. My hair is way too long.
my hair used to be down to the middle and past my back.
Yep,
And-
mine is basically past that now. Don't let it happen again.
Hello. You want to come say hi to the chat?
Hi, Shay. Hey, Shay.
You want my headphones? Sure. Here you go.
Hello, party
Hey,
people.
you can't see me, but I'm waving to you.
Oh, this right here. Ash
Yeah.
and I had a baby.
Okay.
A baby
And then,
avocado, and I
gotta
call him
tell,
Cavo.
Brandon, thank you so much for his super chat.
Right on. You were both talking at the same time, so I didn't get any of that.
Ash and Carmen had a baby avocado, and I call him Cavo.
And a baby avocado. Okay.
But you gotta give my brother some props for his super chat.
Shout out for the super chat.
We
for the
Yeehaw.
blood relative.
we hit our goal. We hit our goal.
Sweet.
Heck yeah. Let's
Oh,
effing go.
Apparently we hit our goal.
Let's go. We hit our goal. Thank you guys so much.
What it
for
do?
this.
What it do?
Should be an announcer. Anyways, I was coming in here to say good night. I'm going to bed. This is my last
Night, night.
show.
Oh, sorry.
Yeah, it's okay.
So, all right.
Oh, sorry, I bumped you.
That's all right.
Booped you.
Anyways, sorry about that. I had to tell her good night because those are special moments. So we got a few more minutes with this guy, and then we're gonna get straight into our 2-minute verdict.
I mean, let's do this. Let's,
Yeah.
how much longer with this one? I'll let you say.
We got 20 minutes.
Ah, we
And then
got
we have
this.
Yeah, we got a 2-minute verdict.
22 minutes left. Come on, guys.
Yeah, she did a
Easy.
Pam Smart had a 4-minute verdict.
She did a what?
I said Pam Smart at least had a 4-minute verdict.
Yeah, I mean, hey, at this point, they're like, here's the key. Goodbye.
All right, let's finish it up.
Inside a car, within, what did the doctor say? We had to get to him. He's going to live 1 or 2 hours, okay? But in order to save him, we had to get to him in 30 to 40 minutes, okay? So what they have to prove is that if he was there, they have to bring you proof that people passed by that would have stopped. There is not one scintilla of proof. There is not a thread of proof. There is not one bit of evidence that if he would have been left there, that the result would have been any different. There is no proof. And I'm going to tell you what, you can't speculate on it. You cannot base your decision on speculation or conclusion or theory. They can't theorize to it. They can't speculate about it. And they cannot ask you to guess. Because we don't guess people into the penitentiary. If we're going to do this right, ladies and gentlemen, they were required under the law to convince each and every one of you with cold, hard facts, proof from this witness stand that somebody would have found him. And they didn't bring you one thing. They didn't bring you a police officer who said, I went by there. They didn't bring you a fireman that said, I went by there. They didn't bring you an ambulance that said, I drove by there and I would have stopped. They didn't bring you one thing. And because they didn't, you cannot convict her of murder. You cannot convict her of murder if we're going to do this right under the law. And how do you know that these acts is not what caused his death? How do we know, how do you know that what caused his death was a failure to act, a failure to seek medical attention? How do you know that? Because their expert, our medical examiner from Tarrant County, tells you so. It can't be the act has to cause the death. Man, if somebody will grab that and take that back there, please. The act has to cause the death. And if the death was caused by a failure to seek medical attention, they cannot prove murder. Dr. Pirwani, question. Because ultimately what caused Mr. Biggs' death was not getting someone there to take care of him. Dr. Pirwani's answer, yes. Failure to provide medical help. That's what killed him. It wasn't taking him to the garage or parking him in the garage. It was failure to call for medical help. And if their own expert, our medical examiner says that, there are many, many reasons to doubt what caused this death. And if you don't believe that, that came right from the court reporter's test. Ask the court reporter to give you that. Ask the court, because that came right out of that machine. And that's how you know that it was the failure to get help that caused the death, not any act. And our expert said the same thing. I'm going to ask you to do something when you go back there. I want each and every one of you to vote your own individual conscience. This is not a collective effort. These are 12 votes that need to come from right here. And if you don't do that based on the evidence, we're all in trouble. So please vote your own conscience and don't let anybody talk you into anything you don't feel is true or right or comfortable that you agree with. Because if you think for a minute that someday that you're going to be sitting on your porch or laying in bed trying to go to sleep, and the thought may cross your mind that, hey, maybe this really was a failure to act. Maybe Dr. Pirwani was right. Maybe this wasn't murder. If you think that thought will cross your mind, you have a reasonable doubt. And if you don't vote not guilty of murder, there's 2 people that are going to have to live with that. One is Chante, and the other one's you. Godspeed.
And just a moment, Your Honor.
Godspeed. Godspeed.
How disrespectful.
What the hell?
How disrespectful.
Oh my God. Oh my Bexar.
Godspeed? Really, my man?
I mean, I don't even know.
We use Godspeed in law enforcement. I'm gonna punch him. If he's still alive, I'm gonna go punch him. We got
Frank. 40 miles an hour. Godspeed.
Yeah. Yeah, now that's something that we use in, I mean, I know several different occasions use it, but that's something that with law enforcement that we use that I keep very, very close to me. So in this case, you're going to sit here and say Godspeed? Like, go fuck yourself, honestly.
Go back.
I like defense attorneys. They have a really hard job, but that is the absolute worst thing that you could end on. So, all right, we're 52 minutes and 26 seconds in. We got about 15 minutes in, or 15 minutes to go. Sorry.
Right, whoever.
Please, the court, defense counsel, members of the jury. Mr. Kearney's upset. Apparently he's upset with the state, and he's upset with the state's witnesses. And I understand why he's upset. Because there's a fundamental principle about criminal cases. Every defendant is entitled to a competent, aggressive defense. And by this point, there can be no doubt in anybody's mind that Chante Mallard has benefited this week from a competent, aggressive defense. But it is equally true that every crime is not defendable. And when you're representing a defendant who has committed such a crime, it's frustrating. And even if you're an intelligent, logical person, what comes out of your mouth to the minds of jurors sometimes seems ludicrous. And I thought it was silly when DeMille said it, our doctor from Bexar County, who forms opinions by looking at this evidence, but doesn't want to look at this evidence. And it's all very simple if you follow his instructions, because what he's asked you to do is disregard our witnesses. Don't listen to them, because they're all liars. They're all liars. These people that were big parts of this woman's life are not credible. So you should disregard them. You know, it's a good thing we never did catch some of the real bad ones. Can't you just hear Hitler's attorney saying, all the state's witnesses are Nazis?
Your Honor,
don't believe what they say.
Objection. He's comparing the defendant to someone like Hitler. That is improper jury argument, and we object to it.
No, sustained.
And we're going to ask the court to instruct the jury to disregard that totally improper comment that he knows is improper.
Jury will so disregard.
And we'll ask for a mistrial.
Denied.
T was such a good friend that she put her liberty at risk. And what did she tell you? When we caught her lies, when she knew we had her, when she knew from records we could prove that she had lied, she agreed to testify. And without her testimony, we would not know the full story of what happened. And you heard her testimony, and you judged her demeanor. And it's very convenient to say, don't believe T, don't believe Cleet, because they're criminals, because they're liars. But who else can the state possibly find to describe the conduct of this defendant if we don't call the people that were around her that night? Again, very simple argument that doesn't stand up to the light of logic and truth. And this is not Chante's fault. That has been the theme throughout this case. This is T's fault. Remember that? Oh, just a week after committing this crime, this horrendous, impossible to understand crime, she's back at the same club she was at that night. That's how traumatized she is. She's back out there, she's got a date, and forms a relationship. Gregory Biggs is hardly dead a week, and she's out on a date. But that was T's fault. That was all T's fault. And it was also T's fault that she went out with him again. And it was also T's fault that she went on that road trip to Ennis with him sometime later. That's all T's fault, not Chante's. And you know, sometimes with all the work we put into cases, important evidence comes out that you're not even expecting. And I want to point something out to you. One of the compelling ways, and there's a number of them that we have absolutely proven to you, that this defendant was aware that Gregory Biggs was alive, and that's what this case comes down to. When she committed the act, and if you can think of a way that you can make a car go from where it strikes somebody into a garage without acting upon it, it just does it on its own, I guess it's the car's fault now too, then fine. But clearly, it is an act. But how do we know that this defendant absolutely knew that Gregory Biggs was alive? Well, it was through the defense questioning it came out. I can't take credit for it. Because what they asked T, when she went there and viewed his body hours later, what did they point out? If she had thought he was alive, she would have called for help. And think about it. Remember the testimony? Remember what happened? Chante's making a phone call in the middle of the night, talking to T, and she's whispering, and she's in the house. Well, who is she afraid of hearing what she had to say? Why is she whispering? Because Gregory Biggs is alive in the garage. And did she let T come into the house when T got there? That struck you as kind of odd? She's not even in the house. She's not going to give her a chance to go in that garage. She's in the side of the house. She comes around and gets in the car. Because you know what? They're right. As much as T may be a liar and have lied to the grand jury, as much as she had made those mistakes, this woman, her best friend, knows that, unlike herself, who has no moral conscience, T would have called for help. And she wasn't going to take any chances about it. She kept her out of that garage until she thought it was safe. And that tells you that he was alive. And this exhibit, I don't know why or where the idea had something to do with hair. What's compelling about this exhibit that they couldn't contradict, and don't you know, if they could find an expert who could explain away a smear, a contact smear from a bleeding hand on the inside of that door handle, they'd have done it. There's no way of explaining that. He was alive. He is gripping the inside of this door handle. There's no question about it. He is aspirating blood from his mouth into the console. There's no explanation for it. That's probably why they didn't want Dr. DeMille to know about Max Courtney's testimony. Because Dr. DeMille doesn't want to be confused with witness statements. He wants to base it on the physical evidence. And wouldn't that be convenient? Let's take all the witness statements, all the descriptions out of this case, and what do we have? We have a vehicle that has the DNA of Gregory Biggs on it. And it's damaged. It's been burned when they discover it. So I guess Gregory Biggs should be the person that we charge with a crime, because Gregory Biggs messed up her car. That is absurd. That is not logical. Their arguments are out of desperation because they don't have a defense to this crime. What about Cleet? Remember, this is Cleet's fault too. She wouldn't have done any of this stuff if Cleet hadn't come over there. Well, who called Cleet? You know, it's about cause and effect. It's about actions. Who did she decide to call? To say that calling Cleet was the problem and that she did not know what Cleet would do for her is like picking up the phone and calling the pizza place and then claiming they made me eat pizza. When she picked up the phone and called Cleet.
So Cleet is the person who testified yesterday. He was one of the people that helped move the body.
His full name is Cletus.
Cletus Jackson.
Cletus.
But yeah.
But you have
he
to
helped
say it
move
like
the body. But ironically, when they were out at the pub or the bar, or whatever you want to call it, he met Chante there, but he left with another female. And then he woke up. I think he just got finished with his business. To like 20 different phone calls and text messages. But yeah, that's who he is. That's who they're referring to.
There's only two things she could have wanted, because there's only two things he can give her. Sex. And I don't think she wanted that night. I sure hope not. Or a crime. Because she knows who he is. And what were her choices? What but two men in her life did she have a choice of calling. And there was a choice. And the choice tells you why it's murder. Because she could have called Cleet, or she could have called her brother, the fireman. But if you want to get rid of a body, you call Cleet. If you want to save a life, as Fireman Souder told you, you call a fireman. From the very moment this crime occurred, she did act after act to make sure she would not be discovered. They made a big deal about the fact that she was upset and impaired, not hearing it in argument, because you got the law now, and you treat her like she's sober. And when you treat her like she's sober, you can look at her employment records, you can see the training she has, and you can understand that she knows what she's doing. She knows what she's doing. As horrendous as it is to accept that a person who has struck someone with their car would make a decision to drive them away from the scene and hide them in a garage and let them die, that's exactly what happened. And no, I don't think anyone who wrote the murder statute ever anticipated that level of evil, that level of disregard for the safety and well-being of others. But it fits. It absolutely fits. And on that night, she meets Mr. Biggs. Now, isn't that a lesson in contrast? Just took us 15 minutes to hear about Gregory. And what do we know about him? The only reason Gregory doesn't have a home is because he made a choice. A friend needed help. He gave her the help she needed. He lost his vehicle. He lost his business. He lost his home. But he didn't lose hope. He never lost hope. And he had the very bad fortune of meeting Chante Mallard. You know, when he talks about Dr. Perwani, it is kind of ironic that he mentions him because there's another part of the testimony. And again, if you're going to ask for questions, if you pick two sentences randomly from this case and base your verdict on those two sentences, just as if you disregard all these witnesses the defendant provided to us by surrounding yourself with them, then yes, we're going to have a problem. But remember what Dr. Perwani told you? This case, in a nutshell, is about this. Did the act of hiding him in the garage contribute to his death? Was hitting him clearly sufficient? Even though our expert and their expert said two things cause his death: the injury sustained and no medical attention. That's what they said. And what did Dr. Perwani tell you? Remember the question? Would he have been better off if he'd been left alongside the road? And what was his answer? Yes. Well, how could he be better off? Well, he had a chance of someone finding him. And no one was going to find him in that garage. And to buy into their argument that that is not true, what you are basically saying is that here in Tarrant County, as people drive down a road, and you can use your common sense and reasonable inferences from the evidence. I don't think there were roadblocks announced. There's no evidence that cars were stopped somehow from traveling down that roadway. For you to buy their argument, what you are saying, to find he's not guilty of murder, but just failed to stop a red raid, you are saying we don't have anybody in our community that, seeing his condition, would have stopped and tried to help. Everybody would have reacted the same way that Chante Mallard reacted on that date. An act clearly dangerous to human life. He never had a chance. She took it from him. So please, remember the evidence. Consider the proof. Follow your hearts. Use your common sense. Go back back in that room, elect a foreperson, and do something to send a message very clearly to her that this is not just failure to stop and render aid. She stole his life. She stole his hope of anyone else saving his life. That's murder. First verdict form. Thank you.
Ladies and gentlemen of the jury, all the evidence, court's charged.
I mean, wow.
Yeah.
I mean, what in the beep was that?
Yeah. My bad, sis.
That was
Cluster?
a lot. Yeah, it was a lot of,
Yeah. Well, we got 2 more minutes left. We're gonna get straight into the verdict. But once we do this, we are not done with the case. And I will tell you why afterwards. So let's do these 2 minutes of verdict.
plot twist.
Share the screen.
2 minutes. 2 minutes.
All right. Jury sent out a note that they've reached a verdict. State ready?
Ready, Your Honor.
Defense ready?
We're ready, Your Honor.
I'll admonish everybody in the audience that there is to be no reaction no matter what the verdict is. Bring in the jury. I'll ask the presiding juror, has the jury reached a verdict?
Yes, it has.
Would you please hand the verdict form to the bailiff? And I'll ask the presiding juror, is this the unanimous verdict of the entire jury?
Yes, Your Honor.
All right. In cause number 0837152D, Style State of Texas versus Chante Mallard. Verdict form is to count 1. We, the jury, find the defendant, Chante Mallard, guilty of the offense of murder as charged in count 1 of the indictment signed by the presiding juror. As to count 2, we, the jury, find the defendant, Chante Mallard, guilty of the offense of tampering with evidence as charged in count 2 of the indictment signed by the presiding juror. Does either side request a poll?
Not from the state, Your Honor. No, Your Honor.
Ladies and gentlemen, you may be seated. Ladies and gentlemen, I'm going to accept your verdict and have it filed with the clerk of the court as the unanimous verdict of the entire jury. This concludes the first half of the trial. Y'all have been more than patient with us. It being
Blah, 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 blah. That he goes through. Yep, guilty. But we are not done. Tomorrow, we are going to go into the penalty phase. So character witnesses and
Mushroom cap lady? Sorry.
We'll go through, we'll do it. We'll start with mushroom cap lady. But it's like Frank said, to be continued because we are not quite done with this. So we'll finish up. But yeah, now you guys know closing arguments. You guys know the verdict, but it's not over yet.
Yeah.
And yeah, shrooms. That's what she probably should have took, I guess. So I don't know. I don't know.
Probably.
I've never taken that stuff. So. But all right, guys, we're going on pushing 3 hours. My mom likes to keep it under 3. So thank you all for hanging out with us. We'll be back at 6 p.m. Eastern Time, 5 p.m. Central Time, 4 p.m. Mountain Time, 10 a.m. the following day. Antarctica time and 69 p.m. Vagina. If something's burning, please go see a doctor time. So
you're gonna need some cream if you gotta do that time.
Yeah, you need some cream. But thank you guys so much. Apparently my mom put a new outro video, so please stick around for that. I haven't even watched it myself.
Hey.
I'm scared.
Hey, nice streaming with you, Jimmy Neutron.
Shut up. See you guys.